started. We have one preliminary matter that I'd like to address. Commissioner Duffley she has a conflict for a short period of time this morning. Do any of the parties have any objection to her reading the transcript during the portion of the hearing in which she has to be away?
No objection.
No objection.
Has no objection.
No objection.
Okay. Okay, let the record reflect that none of the parties have any objection. With that, we will proceed with Witness Barnes, if you can return to the witness stand. Good morning, Mr. Barnes, and you're still under oath. I believe that there's some additional questions from the commission. Chair Mitchell.
Good morning, Mr. Barnes. Just a few for you. I want to walk back through your testimony on Schedule MBR. And Commissioner Clodfelter covered some of this with you yesterday, but I just want to make sure I understand your testimony. And more specifically, the analysis that you performed. Just at the outset, can you walk me through your understanding of the Schedule MBR? How does it work? If I were a customer wanting to participate, how does it work?
I mean, it's basically like kind of traditional net metering insofar as you're able to offset electric usage on site kind of directly. As your system produces electricity, it goes to your house first and then onto the grid if there's excess. That excess is essentially kind of rolled forward and then offsets, future times when you are pulling electricity from the grid at a one-to-one, retail kilowatt hour basis. As the company initially proposed, that accumulation of credits would reset on January 1st, and then later kind of voiced some openness to, other options for that reset.
Okay. And the SSC, how does that work?
It's a monthly, you would consider it kind of to be a monthly fixed charge based on the nameplate capacity of the system. So, $6 times whatever the system size is your monthly additional charge that you pay in addition to the fixed customer charge.
Okay. And what is the limit on system size?
If I remember correctly, it's 20 kilowatts for residential and 1,000 kilowatts. I don't have the tariff right in front of me, and 1,000 kilowatts for non-residential.
Okay, that sounds about right. Okay. So your testimony covers some of the issues that you have with respect to the methodologies that the company used with respect to this tariff. So I'm interested in what you call the first error. Can you walk me through the first error?
Sure. So if you were to look at Witness Haley's exhibit RH19A, what you're going to see is and
that's to his direct testimony?
That's to his direct testimony. There are other versions of that have been filed supplementally as revenue requirements change. But essentially what Witness Haley did is he took, first made a calculation of what the effective kind of capacity of customer-sited solar would be at offsetting demand costs. And that's done based on, the level of alignment between solar production from some of the solar production metering data that they have with, the company's, peaks for DC transmission, for Bremco transmission, for Carolina Power Partners production generation. So there's, in RH19A, you're going to see these percentages that are applied that effectively kind of derate the value according to how well it aligns with the company's peaks.
So derates the value of the solar system.
Yeah, it's like saying, well, we can only expect a 1 kilowatt system to produce 200 watts based on its production profile at the time of, the monthly peaks that determine our costs for Carolina Power Partners.
Okay.
So it's like an effective, an effective load carrying capability or something similar to that.
Okay.
Now, I don't have an issue necessarily. I'm sorry, I think I keep interrupting. I don't have an issue. You know, that's an appropriate thing to do when you're trying to define what the value is for solar against time varying rates that are different depending on what time demand is incurred. It's kind of a feature of all valuation of solar studies. The issue I have with witness Haley's testimony is that what he multiplies those percentage numbers by is the flat volumetric retail rate for the residential class in his direct testimony, and then he did similar calculations for the other classes in his rebuttal testimony. The problem with that is that now you've already gone and derated solar based on its ability to kind of match the company's peak that determine costs. When you base the other part of that calculation on the flat volumetric retail rate, you're essentially further derating the value because you've taken something that is a cost that's caused by demand during peak periods and then averaged it across all customer usage, because that's what the flat volumetric retail rate is. So you've taken, you know, what amounts to cost caused by peak demand and reduced that to an averaged cost, or the cost of average demand. But that doesn't change the fact that those costs are still caused by demand during peak periods. So my calculation, rather than use the volumetric retail rate, I calculated the unit costs on a dollar per kilowatt basis for the respective demand-related costs. I applied a effective solar capacity contribution to those, and came out with a dollar amount. So if the unit cost is $50 per kilowatt and solar's capacity contribution is 20%, then the value is $10.
Okay. So that's helpful testimony, and I'm going to ask you to go through it again, but more slowly and more simply. And I want you to do two things. First, explain what the company did. You've already done that in your testimony just now, so I'm asking you to go back and do it again. But
Okay.
explain what the company did, and then explain what you did.
Okay. The company's calculation in terms of,
And to be clear, we're talking about the development, the methodology for the development of the SSC. Is that correct?
that's right, yes. So the way the company calculates the value of solar in terms of dollars and cents, dollars per kilowatt hour, is average retail rate times the effective solar capacity contribution. So it's 3.5 cents times 20% produces the value rate. And they do this for multiple different demand-related costs: Bremco, distribution, Carolina Power Partners, production demand, and DC transmission. When they calculate that value, so what you end up with is, as reflected in the initial REH 19, is a value of about 7.9 cents per kilowatt hour after all is said and done. That includes other like energy related costs that are just passed through on a one-to-one basis, as well as those kind of derated dollars and cents per kilowatt numbers for demand related costs. You sum that up to 7.9 cents. You look at, well, basically the calculations aren't exactly like this, but basically you look at, well, what's the retail rate? Like, what is the rate at which the customer saves? According to the initial testimony, is about 14.8 cents per kilowatt hour. 14.8 cents minus 7.9 cents, the cost is 14.8 cents per kilowatt hour. The value is 7.9 cents per kilowatt hour. You have, a deficit. You take that deficit and multiply it by the company's, expected solar production from, a unit of systems. and you come up with, you know, a dollar amount for what the deficit would be. Then you divide that by, you know, a reference amount of capacity in order to create the capacity charge. So you say, you know, there's a $1,000 deficit across, you know, the residential class. There are 50 kilowatts of residential systems. Therefore, the standby charge is 1,000 divided by 50. Those aren't the exact numbers, but
So you've said capacity charge and standby charge, but what you're specifically referring to is the SSC, is that
The
right?
FSC,
Okay.
yes.
Just want to make sure the record is clear here. Okay. All right, so that's what the company has done. And then what is your proposal? How would you do it?
the only difference in that calculation that I made was rather than use the flat volumetric retail rate, I used the unit costs, which are derived as basically take all of the costs associated with this particular cost center, like Carolina Power Partners for the residential class, divide that by the demand for which the demand factor that determined that allocation to the residential class, and you get a unit cost, dollars per kilowatt. That's the cost of residential demand during peak times. So rather than use the residential retail rate, I used that number to then calculate, did the calculation of effective solar capacity, multiply that by the unit costs, and you get a dollar amount. And that's, the amount that a given tranche of solar would save New River Light and Power over the course of a year, because we're talking like the test year annual period. To translate that to a solar value rate, I divided that by, expected solar production per year. So divide $10 by 1,200 kilowatt hours for each kilowatt. And that produces my estimate of the value of customer sited solar in terms of dollars per kilowatt hour. I should also mention that in addition to, because of some of the kind of like missing data issues associated with the company's solar, like actual solar production metering data, I constructed multiple scenarios just using kind of like hypothetical solar production profiles, just to see whether or not that those effective solar capacity contributions would differ a lot.
So I'm going to stop you there because I need you to help me understand where the solar production comes into the calculation. So the company starts by looking at the solar production or solar output during its peak periods. Is that correct?
Right.
And so is that where they're using the meter data?
That's right. Yeah. That they use that to construct those percentages that I mentioned.
So, okay. And so is that where the missing data becomes problematic when they're developing those percentages?
Yeah, that's because as I mentioned, there are a lot of daylight hours missing from those hourly numbers.
So do I understand your testimony to be that you used effective capacity of solar production, but the contribution that solar is making during peak periods is understated because of the missing data? Is that your testimony?
I guess not exactly. I noted that because it would be preferable to be able to rely on actual, metered production data in order to make these calculations, because there are lots of variations in systems that, might cause systems in New River Light and Power's territory to be a little bit different than a hypothetical south-oriented or southwest-oriented system. So my preference would have been to use actual data, except, when you're faced with that amount of missing information, it caused me to kind of go in another direction. So rather than try and fill in all of those blanks, I decided to kind of perform a sensitivity analysis and look at the same question using a hypothetical south-facing solar, hypothetical southwest-facing solar, hypothetical southeast-facing solar.
And is that where you relied on PV watt?
That's where I relied on PV watts.
Okay, so the issue you have, so let me back up. The difference between your calculation and the company's calculation, as I understand your testimony, rests on your use of unit costs versus the company's use of the volumetric rate. Do I understand your testimony correctly?
That's right.
Okay.
Demand unit cost versus flat volumetric retail rate.
And then explain one more time, this will be your third time now, maybe your fourth, why your preference is for the demand unit cost.
Because the volumetric residential retail rate is reflective of those demand-related costs spread across all hours of the year, spread across all customer demand. And therefore, it diminishes it essentially kind of eliminates the time varying character of those costs. And yet we've already performed an adjustment to reflect how solar contributes to the time varying character of costs. So we've effectively derated the value of solar twice, once by, reasonably by calculating an effective capacity factor, and another time by using an averaged, the average cost of demand rather than the cost of peak demand.
Okay, so you use the word derate, and you said the company derates, or you testify that the company derates the solar twice. But isn't it actually the case when the company is looking at the solar's contribution to peak periods, is they're trying to determine exactly how much that solar facility is contributing at that moment in time? It's not necessarily a derate, it's what is solar doing at this moment in time?
Right. Yeah. It wasn't. I entirely agree with that exercise of calculating effective solar capacity. I think I used the term derate just because I couldn't come up with another one.
And that's fair. I just want to make sure I understand. You're not saying that the company unfairly penalized solar once and then is penalizing them again. It's just that the company arrived at a contribution to capacity. I mean, a contribution to peak, which takes into account how much solar is contributing at a specific moment in time.
Right. Yeah. And I
Okay.
did the same thing in my
Yes. Okay.
for the narrative.
I just wanted to make sure that I'm clear and that the record was clear. Okay. Can you, I think you've got me there. So I apologize for making you go through all of this again with me. Your testimony suggests that there not be a credit reset at the end of the year or January 1 as proposed initially by the company. Is that correct?
That's right.
Okay. And then my understanding in reading the company's rebuttal testimony is the company is open to that, to eliminating the reset. Is my understanding and your understanding the same?
Yeah.
Okay. And then in the stipulation suggests that the company and the public staff have had some discussions about this, and that I read the stipulation to be that the company and the public staff have agreed to allow this tariff to remain in effect as proposed for 5 years, and then to revisit the issue. Is that your understanding?
Yeah, that's my understanding as well. Since I didn't see anything saying that annual reset should change in the stipulation.
Okay. Okay. When you were working through your understanding of the company's methodology and developing your own methodology, did you have any discussions with the public staff?
I didn't have any kind of like informal discussions with the
Okay.
public staff.
Did you, in your review of documents and records in this case, did you review the company's agreement with Carolina Power Partners?
I don't think I reviewed the specific agreement, but I did review basically a spreadsheet that's kind of detailing what their costs to Carolina Power Partners are, and how those costs are incurred.
Okay. When does New River's peak occur?
Principally in the mornings during the winter and during the afternoons during non-winter months.
So when is
Like
what was the highest peak for New River during the test year?
I think the system peak would have been in January, but I I don't remember that specifically. It is in my work papers.
Okay, like 6 o'clock in the morning?
It was later than that.
Okay.
It was either 8 or 9, I think.
Okay. All right, I have nothing further. Thank you, Mr. Barnes.
Let me just follow up on a couple of Chair Mitchell's questions. In regard to the annual reset, that's in the stipulation that that it will be reviewed in 5 years. Presumably during that period, there'll be more subscription to the NBR schedule and also some more data. So can you explain why a review in 5 years you would not be recommending or you think would not be appropriate? What's the problem with waiting for the 5 years for a review at that time?
Well, my concern would be that, all of those customers that participate are going to be overcharged for 5 years. I certainly don't have a problem with a review on any cadence. I think what I would prefer is that, based on my analysis, kind of full net metering without the standby charge be allowed to go into effect, and perhaps when the company can, I don't know, fix the production metering issues and develop kind of a complete data set that maybe that could be reviewed in 2 years' time or something like that. I don't know why it's necessary to wait 5 years. I guess I don't have an ideological position on what time frame is necessary. It feels like it's, at least a year in order to assemble the additional data.
To make sure I understand though, isn't the overbilling issue that you're talking about, isn't that a separate issue than the annual reset? That is a separate issue than that needs to be solved in your mind or your position in a different way than the annual reset. Is that correct?
Well, so if we have that annual reset on January 1st, the way the company did the calculations, they didn't take into account that customers may forfeit a certain amount of their excess production over the course of a year. So there would be, the two are kind of interconnected in that way, the supplemental standby charge and the annual reset. So, all other things being equal, that would have to be kind of fixed in, say, setting a supplemental standby charge if that element was retained. Given that customers would presumably understand that sizing their system up to 100% would result in the forfeiture of credits, having a review in 5 years' time with customers kind of fully informed and able to size their system so that they don't incur that forfeiture, that could be reasonable. I dislike the fact that it really prevents you from sizing a system in a way that lets you fully offset your on-site load. So that's my principal kind of objection to that annual reset, beyond kind of the calculations, is that, it doesn't let you offset all of your on-site load over the course of a year without incurring the forfeiture of credits.
Okay. And then one last question from me. This relates to the SSC, and I want to give you an opportunity to explain again or to better explain why you think that it should be based on the system design capacity rather than the nameplate capacity of the inverter. So I know you touched upon it a little bit yesterday, but can you again explain why you think the company's position about that is incorrect?
Okay, so I can use a specific example of a system I installed on my home in Raleigh years ago. The nameplate capacity, like the nameplate capacity of the solar panels on my roof, is 2.9 kilowatts. The nameplate capacity of the inverter is 3.5 kilowatts. The reason why the nameplate and capacity of the inverter is higher than the nameplate capacity of the system is just because they don't make 2.9 kilowatt inverters, or you can't necessarily directly match the size of the system with the size of the inverter. The problem with using the inverter size is that it's often the case that the inverter is going to be sized at least somewhat larger than the design capacity of the system. And the design capacity of the system, not the inverter size, is really what determines how much energy it produces. So when you've got a calculation of an SSC that's really, kind of at its core still based on how much electricity is the customer avoiding purchasing from New River Light and Power, and what is the cost of that, you have to use the system production capacity, not the inverter nameplate capacity.
And is there any difficulty for the company in providing, I think, providing the nameplate capacity of the inverter is kind of a simple exercise. Is it any more difficult for the company to have information about the system design capacity as opposed to the inverter capacity? Is there administratively, is this going to be problematic for the company?
I don't see any reason why it would be. I mean, you can collect that both pieces of information as part of an interconnection agreement. I mean, in fact, I think they actually do that already. At least it's a line on the form.
Mm-hmm. Okay. Thank you. And Commissioner Hughes, did you have a question?
Yeah, one just a quick follow-up on the inverter question. I mean, I know we're only talking about 10 systems, but in the data or whatever they had good data for, did they actually look and see if the outputs were higher than the nameplate capacity? I mean, I understand the 2.9, but I mean, you've probably actually followed your system, I imagine, quite closely. Has it ever produced more than 2.9? Because even that 2.9, I understand, is an estimate. So
Yeah, I mean, it wouldn't be capable of producing more than 2.9 because that's like the maximum ratings of the panels themselves. Like each panel is X amount and you sum them all together and that's the design capacity.
okay,
I don't think I don't know the New River Light and Power. They don't know the capacity of all the current systems. I think they know 9 and 6 are missing.
okay. I just didn't know the technical. I didn't know if the 2.9 was an underestimate, but you answered it. The 2.9 is absolute physics cap for your system.
Right, that's correct.
Okay. I thank you for going over with Chair Mitchell the explanation of the SSC. I think I understand it myself now. The way I would look at it, and I just want to verify that it's correct, is there was a lot of effort to try to figure out when the solar systems are producing the energy, but there was not any effort really to figure out the cost that matched with that time when they were producing it. Rather, instead, they fell back on an average price, which is very different than cost. So is that kind of the unequal treatment? Is, they did go ahead and figure out when it's going into the system, and there is good data on the actual costs then because you have the contracts, but they didn't use those costs. They just went back to using this.
They used what I would call kind of the proximate cost to New River Light and Power. And the proximate cost, if you're looking, at the solar cost benefit equation is, well, how much do customers save? And that's determined by all of those flat volumetric retail rates. So I don't have an issue with kind of calculating cost based on that, using kind of that equation. Because I mean, yeah, literally, like if a customer saves $100, it's $100 that New River Power doesn't get. Now the customer is providing something else in exchange for that $100. But, I don't have a problem with saying, yeah, the cost is basically system production times the retail rate, because that's what a customer saves.
Okay. I'm not sure the timing of when you did most of your analysis and whether it was pre or before, pre or after some of the new subsidies and credits that we're going to see rolling out for batteries and for systems, for solar systems. But first off, did you look at those and just run any kind of analysis, or have you done it for other types of analysis that you've done, the impacts on those customer credits for solar systems, but also for batteries? And I didn't see a lot of discussion in batteries in this case, in storage, what would happen. But if we're talking 5 years, this is system, these rates are in place for 5 years. If in 3 years, the cost of battery storage is much lower, and a customer could conceivably greatly increase that capacity factor by having on-site storage, then it would seem like that there's a large underestimate of the value of that electricity going back to the back into the system. Does that make sense?
Yeah, so I guess there's a few things I want to say if you'll indulge me a bit. So one, I didn't do like a payback period analysis or anything like that. Like I didn't look at like what the financial impact of the supplemental standby charge would be on like customer savings, or how long it would take their system to pay them back for what it cost them. So that just wasn't part of my kind of consideration. As far as batteries are concerned, with a flat retail rate, that being what it is, there's not really a use case for batteries for the customer. I mean, they don't get anything out of having a battery other than, backup capability. So they wouldn't have much of an incentive under the current rate structure to kind of operate a battery in a way that, is kind of increasing the value of their system. That could be accomplished if there were like time of use rates that were kind of telling them when energy was more expensive or less expensive. But kind of under the flat retail rate structure, they don't really have a reason to, really use the battery at all other than to provide backup power. But in theory, yeah, you can do a lot of things with batteries. One of those is kind of, firm up the contribution to capacity, by saving that electricity, that excess electricity that would have gone on the grid at 2 PM, which is off peak, and then, discharging it at 6 PM, which is more likely to be an on peak period.
Makes sense. If the reset does occur, then there would be a small value add for potentially reducing that reset amount, right? With that, batteries would conceivably allow you to possibly reduce the reset amount, or
I mean, the maximum storage capacity of a typical residential battery might be 13.5 kilowatt hours. So you could reduce it by that amount. But it would be kind of small potatoes in the context of, what you might expect it to be, which could be hundreds of kilowatt hours that get forfeited.
okay. Well, and then just you can indulge me further. So in your opinion, anything that we're looking at would not be an incentive for further reduction of cost that the utilities are going to incur by using batteries. There's no incentive on the customer level. There's no incentive in the rider that we're looking at to encourage storage, even though we know that it would be possible to reduce the utilities costs and therefore the customer base's cost.
Right. Yeah. I mean, there's no ingrained incentive in the rates, and there's no ingrained incentive in Schedule NBR as it's been proposed to use storage.
And does that concern you?
In an ideal world, we would have time of use rates. I mean, that's something I would kind of consistently fall back on. Time of use rates are better than flat rates at reflecting cost causation. And that would kind of create some incentive. Whether that's enough to kind of spur battery adoption is a different question. But, there are other opportunities that, could be deployed. I think you've seen some of those, some of Duke's, recent proposals for using, I can't remember what the residential load management programs. I mean, those are the kinds of programs that, in my view, kind of can pretty effectively utilize batteries and not underuse them to avoid costs caused by peak demands.
Okay, I think that's it. Thanks for that indulgement.
And my last question is it your understanding that New River is planning to develop time of use rates within the next couple of years? Is that your understanding?
I recall seeing, I think it was maybe a 2 to 3 year timeline.
Okay, thank you. Chair Mitchell?
Yeah, we have one last question. is it your position that the SSC should be based on the lower of the inverter or the nameplate capacity of the PV system?
It should be based on the nameplate capacity of the PV system.
Okay.
The design capacity is, I think, how I used that
Okay.
terminology.
Okay. Making sure that gets what the response that we need. Okay, thank you.
Okay, I think that's the end of the commission questions. So we'll now move to questions specifically on the commission's questions, beginning with the interveners, Ms. LaPlaca, if you have any.
No.
Okay, public staff.
Good morning, Mr. Barnes. My name is Tom Felling with the Public Staff. I wanted to just ask you what I think will be one question based on the line of questions you were having with Commissioner Clodfelter yesterday on the standby supplemental charge, and just wanted to make sure we had this clear for the record. I think you indicated that the 592 standby supplemental charge was inclusive of NRLP's distribution cost. But are you also aware that that charge is inclusive of the DEC and Bremco transmission and distribution costs as well?
I mean, I guess it's the way I've seen the calculations, it's inclusive of a portion of those costs, because of the, the way the calculation works is you're not fully offsetting those costs.
Okay, I think that answers my question. Just to be clear, you're aware that all three of those components make up, in some form, make up a portion of the SSC.
Yes, I'm aware of that.
That's all from the Public Staff.
Yes. So starting with the last question that you were asked by commissioners about system design capacity versus inverter, and you mentioned 6 were missing. Does that mean 6 customers did not provide New River Light and Power with their system design capacity? So the utility didn't have that to work with.
I mean, I don't know specifically why it's missing, whether it, got shelved somewhere or whether they failed to provide it on their interconnection application. So I guess I can't speak to that.
You just know it's missing.
I just know it's not there.
Thank you. When Commissioner Mitchell was asking in the beginning, kind of describe how NBR worked, and you talked about the solar generation offsets the usage that's pulled from the grid. Effectively, that means that the solar generating customers are getting full retail value for their solar power. Is that correct?
Yeah, I mean, leaving aside the SSC, that is correct. They're getting, 1-to-1 full retail value.
And that's better than the avoided cost rate that would be available under buy-all-sell law?
I don't know the specific cost rate, but avoided cost rate, but I suspect that's true.
Yeah, retail's normally going to be higher than the avoided cost rate, isn't it?
Sure.
Okay. So that's a benefit of this NBR relative to the old buy-all-sell law.
Yeah, I would say NBR is an improvement in that regard.
Okay. You were also asked about the missing solar production data and whether that was just left out by Mr. Halley in his calculations. Do you understand that he created an estimation and used that in his calculation, an estimation for the data that had been missing?
Yeah, I understand that. In my testimony, I described why I don't think his estimation methodology is very accurate, because, and to explain specifically, there were multiple durations of missing data that might range from a couple hours to 10, 12, 14 hours. And the way Mr. Haley filled in that missing data was to take the reading after the missing data and the reading before the missing data, subtract one from the other, and then spread that amount equally across all of those intervening hours. The reason that's not accurate is because solar produces production according to kind of an upside down U-shaped curve. So it's not as though it produces electricity at a flat rate throughout the course of the day. It does it over the course of this U-shaped curve. So interpolating, multiple hours based on that flat amount spread evenly between all hours just isn't accurate.
Is it, well, I mean, given the lack of data, there had to be some necessary inaccuracy by estimation, given the fact that it is an estimation. Would you agree with that?
Well, sure. I mean, if you're faced with missing data, you do something about it.
Okay.
My preference would have been to, well, we can't rely on this data, and let's use PV watts as I did.
I understand. So you also asked some questions by the commission about the annual reset. And do you understand from Mr. Halley's rebuttal testimony that New River was willing to step aside on that issue, that New River's understanding was the public staff preferred a reset, that Appalachian Voices opposed a reset, and New River decided it wasn't going to take a position on that issue and simply let that be resolved by the commission between the other parties?
Yes, that's what I recall.
Okay, thank you. That's all my questions.
Okay, Mr. Barnes, I have a few here. Going back to yesterday, Commissioner Clodfelter was asking you about the missing, what he called, I think, the missing data issue. Do you recall that?
I do.
And he cited Miller rebuttal testimony, page 6, line 12, which references Miller Exhibit 1, saying NRLP adjusted the amount of renewable energy utilized in its development of schedules NBR and PPR to recognize the portions of hourly data missing from its analysis. Do you recall that?
I do.
Have you had a chance to review Miller rebuttal Exhibit 1?
Yes, I have.
Did it resolve your concerns?
No. So that filling in of the missing data, at least in my understanding, was that rather than use the sum of all hourly readings from their production metering to kind of develop like this is the amount of total solar production associated with these systems, they were able to kind of construct another estimate that I guess is, presumably not an estimate. It's accurate based on using monthly readings. And that, that influences the amount of the calculated SSC, because one of the components of that calculation is, well, how much does a solar customer generate? So they were able to kind of get at that total amount through another way just by using monthly readings rather than just summing all of the hourly readings, which have missing amounts. What doesn't resolve my concerns about that is that there's no way to recreate those hourly amounts that are missing during times of a monthly peak, when New River Light and Power would have incurred costs to serve that monthly peak. So you can't use monthly readings for that purpose. Once it's gone, it's gone. The second issue is that that total energy production still doesn't tell us what the actual nameplate capacity of those systems is. And that's another component of the calculation of the SSC that, can't be, I suppose you can recreate it by contacting those customers and getting the information, but New River Light and Power hasn't done that yet. So that doesn't, the missing data concerns that I raised are not resolved in those respects.
Thank you. So sticking with some questions Commissioner Clodfelter asked you yesterday, he noted that the size of the SSC is based on the nameplate capacity of the customer's system. It's the inverter, and he wanted to know the average size of a system. Do you recall that?
I do.
And you said you had seen the list of customers with solar PV generators in NRLP's responses to data requests. It's come up during the proceeding, right?
That's right.
And have you reviewed NRLP's relevant responses?
Yes, I have.
Could you please tell the commission the sizes of customer-sited solar according to what was provided in general terms?
Yeah, there were in one of the discovery responses, there were 9 systems that had a nameplate capacity listed. The average, I mean, they ranged from, I think it was like 3 to 12.5 kilowatts. The average was about 7 kilowatts. So that's, I think it was 9 out of 15.
And have you calculated the average SSC at $5.92 per kilowatt?
Well, yeah, I mean, if you say, 7 times effectively 6, it would be about $42.
Okay, I think this was also yesterday. Commissioner Kemmerite was asking about the harm that could come from customer confusion about Schedule PPR, NBR and Schedule PPR, and whether anyone would actually prefer Schedule PPR. Do you recall that?
I do.
Could you please explain how Schedule PPR and buy-all, sell-all policies generally affect customer-sited solar generators?
Sure. Well, I mean, and there's certainly a financial impact, like to the extent relative, you're comparing it to, say, net metering. If you're on a buy-all, sell-all and the buy-all, sell-all rate is lower than the retail rate, then all of that electricity that you might otherwise use to directly offset your load goes onto the grid and is compensated at a lower rate than what you would get if you were allowed to directly offset on-site load. Beyond that, like just say in the hypothetical where the buy-all, sell-all rate is equivalent to the retail rate, there are potentially other adverse consequences for, say, a residential customer. One is the creation of taxable income, since it's, amounts that might be distributed via a check that are considered to be taxable income. I'm aware of certain instances where homeowners insurance companies have refused to cover a solar system as part of the customer's homeowners insurance policy because they believe the buy-all, sell-all arrangement was indicative of the system being effectively a commercial power plant rather than an accessory to the home. And have requested that they get commercial liability insurance rather than having their homeowners insurance cover that system. There's also potentially in North Carolina an adverse property tax consequence because of the way that the State Department of Revenue has kind of distinguished between customer-sited facilities that serve primarily the customer's own needs and commercial renewable energy facilities. Those customer-sited facilities are, considered accessories to the home and are exempt from property taxes to the extent they add value to the home. Those commercial systems are not exempt from property taxes and are subject to basically an annual personal property tax as business property. I don't know whether the DOR would necessarily say that under a buy-all, sell-all, this is a commercial facilities, but that is one potential implication. It's not a hypothetical. It has come up in other states.
Thank you. Okay, just a couple more. Moving to this morning, Chair Mitchell and later Commissioner Hughes touched on we spent some time on the solar SSC calculation and average volumetric cost versus the demand unit cost. Is it, just to try and put a bow on it, is it true that the demand unit cost better represents the actual cost avoided by NRLP?
Yeah, it more accurately represents the cost of demand during peak periods than the average volumetric retail rate.
Thank you. So, okay, last couple. Commissioner Kemmerite asked you about the review in 5 years. Are you concerned with, and when we have better data at the end of that, are you concerned that if the policy goes to, the Schedule NBR goes into effect with the SSC as proposed, that we won't see very many signups?
It's certainly a possibility. I'm not going to come out here and predict that there won't be any. But if, there is diminished value for the customer, there's going to be diminished interest from prospective customers.
Thank you. That's all for me.
So we've come to the end of questions on commission questions. So I'll now hear motions from the parties.
New River would ask that its cross-examination exhibits 1, 2, and 3 for Mr. Barnes be admitted into evidence.
Seeing no objection, your motion is allowed.
App Voices would move to have Mr. Barnes' pre-filed direct testimony and summary entered into the record as though given orally from the stand, and to have the exhibits attached to his pre-filed direct testimony identified as pre-filed exhibits JRB 1 through JRB 4 moved into the record. And finally, App Voices would move that Mr. Barnes' supplemental testimony that was given from the stand be moved into the record.
Seeing no objection, your motion is allowed. Mr. Barnes, thank you for your testimony, and you may be excused.
Thank you, Commissioner Chair.
So our order of witnesses is now with the public staff. The public staff may call its first witness.
Public staff calls Finch Zink.
Good morning. You place your left
morning.
hand on the Bible and raise your right hand. And do you solemnly swear that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, thank you.
Ms. Zhang, would you please state your name, business address, and current position for the record?
Yes, my name is Fan Zhang. I am I'm a public utilities regulatory manager in Public Staff Accounting Division. The business address is 430 North Southborough Street, Raleigh, North Carolina.
Thank you. And are you aware that on June 6th, 2023, public staff witnesses Sonia Johnson and Iris Morgan prepared and caused to be pre-filed in these dockets direct testimony consisting of 13 pages and 1 exhibit?
Yes.
And you had knowledge that that testimony exhibit were being prepared at that time, correct?
Yes.
Are you aware of any changes or corrections to that pre-filed direct testimony?
No, I don't.
On July 6th, 2023, did you adopt Ms. Johnson and Morgan's pre-filed direct testimony exhibit as your own and through counsel move the commission to be substituted as a witness in place of Ms. Johnson and Morgan for the purposes of this hearing?
Yes, I do.
And do you have any changes or corrections to that pre-filed direct testimony?
No, I don't.
If you were asked those same questions today while testifying from the witness stand, would your answers be the same?
Yes.
On July 6, 2023, did you prepare and cause to be pre-filed in these dockets testimony in support of settlement consisting of 4 pages, an appendix, and 1 exhibit?
Yes.
Do you have any changes or corrections to your pre-filed settlement testimony?
No.
If you were asked those same questions today while testifying from the witness stand, would your answers be the same?
Yes.
Presiding Commissioner Camerite, at this time, I move that the pre-filed direct testimony and settlement testimony appendix of public staff witness Fin Zhang be entered into the transcript at the appropriate time as if given orally from the stand, and that witness Zhang's direct and settlement testimony exhibits respectively entitled Public Staff Accounting Exhibit 1, Settlement Exhibit 1 be marked for identification as pre-filed. Ms. Zhang is now available for cross-examination if that's the case.
So the direct testimony filed on June the 8th of 2023, consisting of 13 pages, and the settlement testimony filed on July the 6th of 2023, consisting of 14 pages, will be copied into the record as if given orally from the stand. The 2 appendices attached to the direct testimony and the 1 exhibit attached to the direct testimony, and the 1 appendix and the 1 exhibit attached to the settlement testimony will be marked for identification purposes as pre-filed.
Thank you. Ms. Zhang is available for cross-examination.
Beginning with Appalachian Voices.
Nothing from Mount Voices.
Okay. From New River?
No cross-examination.
So Ms. Zhang, the commission staff has several questions for you. And first of all, relating to the stipulation. On page 4 of the stipulation, item 16, that relates to the accounting adjustments. Did the parties, and I can wait till you get there.
Yes, I'm here.
Okay. Did the parties intend for the agreed upon deferral amount of $364,646 to be repeated the next two times in this item where the $346,646 is stated? In other words, are there two typos? Should all of the numbers in this paragraph be the 364,000, 646,000?
Yes,
Okay. So there are two typos, is that correct?
yes, I think we addressed on the preliminary matter at the time by New River.
Okay. And then a follow-up to that question, was the agreed upon amount of the $364,646 the result of a calculation? For example, did the parties agree to the recovery of the UBIT for certain years, or is the $346,646 an agreed upon percentage of the total amount that the company requested?
That these of 364 646 dollar is the estimate tax liability for the fiscal year 2023. Yeah.
And that was agreed upon with the company, is that correct?
Yes, we settled with that amount.
Okay. And then did the public staff agree with the revised calculation of the amount of $931,544 that is reflected in the Jamison rebuttal exhibit number 2?
Which, do you mind point me to the page? I may not have.
Okay. So it would be under rebuttal exhibit 2. Perhaps your attorneys might have that to provide to you. Yes, you may.
So which line are you referring to?
I don't have the line. I just have it as exhibit number 2.
Okay. So I had to check because I'm not sure this one is this one the update provided by the company. If so, yes, it should be the last. You can see the fiscal year 2023. Those sum up. It should be. So you see the last 10 line. Those summed together except the refund. So the title on the second to the last column, the first like fiscal FY23, all those sum up together. Those are the estimate because the company had to pay each quarter had to pay the estimate tax based on their estimate tax liability. So they provide that to us upon our request at that time. Yeah.
And to make sure I understand you correctly, is the total that you're talking about, is that the approximately $931,000 amount?
No.
What amount are you speaking to then?
The total should be the 364,646. So if you sum up the last like the line, last 10 row, but except the refund from the fiscal year 2022, like
Okay.
title as FY 2, 3, first, second, third, fourth quarter. So those sum up, you will be getting the 364.
Thank you. And then a follow-up question, we just want to make sure we're clear on the record. Is the company and the public staff, are you agreeing to not having no unamortized balance in the rate base related to the UBIT deferral?
Okay. The unamortized balance, you will stay in the rate base. So like, let's say because they amortize over 3 years, so after first year amortization, the remaining 2 years is included in the rate base.
So it will be so to make sure we're clear on this, the unamortized balance will in fact be the position of the parties, the public staff and the company, is that it will be included in the rate base.
Yes.
Okay. And then moving on to the AFUDC rate, and I'm looking at rebuttal testimony of New River's witness Hallie. And this will be on page 24. And I can summarize what he stated, and that if you need to see it, one of your attorneys can provide his testimony.
Okay, thank you.
But on page 24, which would be lines 8 through 12 in his rebuttal testimony, he states that the public staff has proposed to calculate all of New River's AFUDC based on the public staff's proposed rate of return rather than New River's currently approved rate of return. Can you explain how this issue was resolved between public staff and the company in the stipulation?
Yes. So in the stipulation, we have already settled with the approved rate, which will be the 6.525%, I believe, our. So we have resolved that, I believe.
I'm sorry, can you repeat your answer so I can make sure I understand?
Okay, so in the settlement, we are using the method based on the prior rate case, and that is agreed upon by the company. So when we calculate the AFUDC rate, that is based on the ROR of 6.525, I believe, but I can check, let me check my schedule. I believe that's the, yes. So it's based on the approved last rate case ROR.
Okay.
And the method we're using is based on the prior case, and that the company did not object that in the last rate case, the method, the public staff calculating.
Okay, so the company agreed to the use of the currently approved rate of return in the stipulation.
Not the currently approved.
The past rate case.
Yes,
Okay.
the RR approved in the last rate case.
And then can you explain the public staff's rationale for using the proposed return rather than the commission-approved return to calculate the AFUDC? Is this a change in the public staff's policy? And can you provide the public staff's position about this?
So, because I did not work on the last rate case, so I don't know what is actually used on the last rate case for the approved RR or the proposed RR. So if you don't mind, I can file a late file exhibit for the response on that piece.
That would be fine to file a late file exhibit, but this question came from the commission staff, but I think that your answer was that the use was the return was based upon the not the proposed rate of return, but the past rate case rate of return. Is that correct? So my question was probably not applicable since we're talking about use of the rate of return in the last rate case. Is that correct?
Yes, but, because AFUDC is calculated for the plant in service at the time, like from the construction until they place in service. So in this rate case, we settle with like it's more appropriate to use the last approved ROR because that capital investment is not decided on this rate case. So we settle with that number.
Okay, so my last question was actually not reflective of the answer that you previously provided. So I don't believe that we will need a late filed exhibit.
Okay, thank you.
Thank you. Any questions from the commission? Chair Mitchell.
All right, Ms. Song, I have a few for you. Can you look at your settlement testimony, Exhibit 1, Schedule 2, please, ma'am? Just let me know when you get there.
Yes,
Okay, I'm interested in lines 9 and 10 specifically. I see the public staff made adjustments there, and so I want you to walk me through those adjustments. But before you do that, will you explain what each of those line items describes, the type of costs those line items describe?
okay. Are you talking about line 9 and line 10, the cash working capital?
Yes.
Okay, so those adjustment, it has two parts. One part is the calculation on the cash working capital. They're using the 1/8 of the O&M cost. So yeah, 1/8. Yeah, 1 divided by 8. And then there's a second part of the public staff adjustment is the bring up to the 2022 updates. So those are based on, so what we do is based on the actual 2022 update amount of O&M and calculate our cash working capital they need for the company. And that amount we settle with the company and then compare that to the application amount. So that's the column E, you're seeing that is a total adjustment.
Okay, so just thank you for that clarification. Just want to make sure I understand you. So I'm going to explain how I understand, and then you tell me if I'm right or wrong.
Mm.
So those two adjustments, the public staff adjustments shown on lines 9 and 10, simply correct the amounts to get them to 1/8, the 1/8 cash working capital standard, so to speak, and then what was the second adjustment?
Second, because we
through
have
the adjustment.
Yeah, update.
Through the update period. But the public staff didn't make any substantive adjustments to those expenses.
No, because they are just based on 1/8 of the O&M, so they're
Okay.
using the formula method. And then for the purchase power, they will have the lead lag day to calculate. So for the purchase power, that line 9, that line is the lead day or the lag day based on the purchase power. They receive the revenue or the cost they pay. So I believe it's about 12.5 days.
Okay.
I had to check my schedule if you need it.
Okay. All right. That's sufficient. I appreciate that. Did you have an opportunity to review any of the company's exhibits filed with settlement testimony?
Some degree.
Okay. Well, I'll hold my questions for the company then. That's all I have for you. Thank you, ma'am.
Okay, thank you.
So that is all for the commission questions. Thank you. And now we'll move to questions on commission questions.
None from New River.
None from Bad Voices.
None from me.
No. Thank you.
Well, that is all. So thank you for your testimony. Are there any motions that the parties would like to make?
Yes, please. Presiding Commissioner Cameron, bulk staff would move that the exhibit attached to the pre-filed direct testimony as adopted by Ms. Zhang and the exhibit attached to the pre-filed settlement testimony of Ms. Zhang be entered into the record and marked for identification as pre-marked.
Seeing no objection, the motion is allowed. And Ms. Zhang, you may be excused.
Thank you.
And I believe that the next order of witnesses, Mr. McLaughlin.
Thank you, Presiding Commissioner Kimmerer. Would call Mr. McLaughlin to the stand.
Good morning.
Good morning.
Place your left hand on the Bible and raise your right hand. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
Mr. McLaughlin, would you please state your name, your business address, and your current position for the record, please?
James McLaughlin, 430 North Salisbury Street, Raleigh, and I'm the Director of the Public Staff's Energy Division.
Are you aware that on June 6, 2023, Public Staff Witness Jack Floyd prepared and caused to be pre-filed in these dockets direct testimony consisting of 29 pages, an appendix, and one exhibit?
Yes,
And was that testimony and exhibit prepared with your knowledge and under your supervision as Mr. Floyd's supervisor at the time?
yes, it was.
And are you aware of any changes or corrections to that pre-filed direct testimony?
No, I am not.
And on June 30th, 2023, did you adopt Mr. Floyd's pre-filed direct testimony and exhibit as your own, and through counsel move the commission to be substituted as a witness in place of Mr. Floyd for the purposes of this hearing?
Yes,
And if you were asked those same questions today while testifying at hearing from the witness stand, would your answers be the same?
yes, they would.
And on July 6th, 2023, did you prepare and cause to be pre-filed in these dockets testimony in support of the settlement consisting of 6 pages?
Yes,
Do you have any changes or corrections to that pre-filed settlement testimony?
no,
And if you were asked those same questions today while testifying from the witness stand, would your answers be the same?
yes, they would.
Presiding Commissioner Kimmerer, at this time, I would move that the pre-filed direct testimony and appendix and settlement testimony of Public Staff Witness James McLaughlin be entered into the transcript at the appropriate time as if given orally from the stand, and that Mr. McLaughlin Exhibit 1 be marked for identification as pre-filed.
So the direct testimony of Mr. McLaughlin filed on June the 8th of 2023, consisting of 29 pages, will be copied into the record as if given orally from the stand. The one appendix and one exhibit that was attached to the direct testimony will be marked for identification purposes as pre-filed. And his settlement testimony filed on July the 6th of 2023, consisting of 6 pages, will also be copied into the record as if given orally from the stand.
Thank you. Mr. McLaughlin is now available for cross-examination.
So cross-examination from Appalachian Voices.
Thank you. Mr. McLaughlin, just to start with, I'm going to say you testified, I'm referring to Mr. Floyd's testimony that you adopted. Is that okay?
That's fine.
Okay. So you testified that Schedule NBR, and I'm quoting, makes a reasonable effort towards compliance with H 589 on page 14, lines 5 to 6.
Yes,
NRLP doesn't have to comply with H 589, does it?
And I would object to that question just to the extent that it calls for a legal conclusion, and to the extent that he's able to answer it under his own personal knowledge. I think that would be appropriate.
I would just say it's no more a legal conclusion than his own testimony, which I'm asking about. The public staff should not be allowed to, or anyone, offer a legal opinion in expert testimony and then insulate that opinion from cross-examination.
So the objection is overruled. Mr. McLaughlin, recognizing that you are not an attorney, answer the question to the best of your ability.
I think, let me say why I think our testimony is worded the way it is. We looked at 589 and we looked at what it said about net metering and the revisions to current net metering tariffs, and we looked at what New River had proposed in this case, and we felt that if what New River had proposed was in alignment with what 589 said, I will leave it to the legal experts to determine whether they were required to comply with 589 or not.
Okay, thank you. So you testified that you reviewed Schedule IR. This is on page 18, line 15. The interruptible rate.
Yes.
And you found that the $14.26 per kilowatt credit is based on the contract demand charge associated with the purchase power agreement plus an adjustment for system losses. It's on page 19, 12 to 14, correct?
Yes, we reviewed the calculations that the company used to support the $14.26 and found that they were supported.
So you'd agree then that NRLP's costs that can be avoided vary over time?
Some costs vary over time, yes.
And so if a resource contributes to meeting NRLP's needs at a higher cost time, it will avoid higher costs.
It's possible that it could. I think it's important to remember, though, that we work in an average cost and average rate environment, and that's the way rates are designed, to recover average costs over a broad period of time. Certainly within any period of time, not all costs are exactly the same, but that's not the way New River's rates are designed to work.
The rates, but under its costs under the contract vary over time.
Yes, for instance, their contract with CPP, their wholesale power supplier, as fuel costs vary by month, the bills that New River receives from CPP for the cost of that power can go up or down.
You gave me a perfect segue to my next question. Thank you. My next line. So you note on page 9, lines 18 to 19 of your direct testimony that purchase power costs represent approximately 71%. Is that right?
That's correct.
And then on page 10, lines 3 to 8, NRLP has experienced volatility in its purchase power costs.
They certainly did in 2022.
And in that same passage, you note that this volatility drove New River to update its purchase power adjustment rider.
They came in mid-year and asked the commission for a mid-year update to their purchase power cost. I will point out that the volatility that New River experienced during that time was not unlike what other utilities in North Carolina and around the country experienced during that time.
And that was due in large part to the steep natural gas price increase, right?
That was certainly a major component of it, yes.
And that resulted in undercollections?
Yes, from the rate that had been set, from unforeseen cost increases from purchase power rate in New River's case that had been set in advance.
Okay, I think you answered. And that ultimately had to be recovered from customers.
Yes, unless the costs were found to be imprudent, they had to be recovered from customers.
Is it your understanding that New River gets much of its power from the Kings Mountain Energy Center, just a combined cycle plant?
That is where the majority of their power comes from, although they did receive a certain portion of their power from a renewable energy provider during that year, but the majority was from CPP, which is in Kings Mountain, yes.
we're having a telepathic connection this morning. You would agree that solar, wind, and hydro do not have fuel price volatility?
They do not burn fuel, so no, they don't have the fuel volatility that natural gas or coal or even nuclear plants would have.
Yes, please. I have an exhibit I would like to introduce. What's this?
Do you need another one? Go ahead.
Okay, so let's go ahead and get this marked. We'll go ahead and get it marked. We will have this marked as Appalachian Voices Cross-Examination, McLaughlin Direct Exhibit Number 1.
So, Mr. McLaughlin, have you had a minute to review that exhibit?
I have looked over it. I haven't read every word.
Certainly. Do you recognize it?
Can you speak a little bit more in the microphone? We're
Sorry.
having a little trouble hearing.
Sorry about that. Do you recognize it?
Yes, this is the initial filing that New River made back in November of 2022 for their annual purchase power adjustment.
Could you please read the highlighted portion on page 2 into the record?
In the context of these RER calculations, it should be noted that this past year's cost of energy from Carolina Power Partners, CPP, was much higher than was projected at the time of the proposal and approval of the RER offering to NRLP customers. Although the initial calculations estimated an incremental additional cost of renewable energy of approximately 2 cents per kilowatt hour over the cost of energy purchased from CPP, the actual difference was approximately 2 cents per kilowatt hour savings.
Thank you. And could you please review Exhibit D to that document, the 2022 true up? Do you see in the third line, the avoided CPP energy costs are something a little over $1 million?
Yes,
So is it fair to say that renewable energy purchased through rider RER functioned as a hedge against the fuel price spike that we just discussed?
It certainly did in 2022. Yes.
Wouldn't customer-sided solar do the same, at least with respect to the avoided energy cost?
It would have in 2022 when the natural gas costs were extremely volatile. Yes.
Which would decrease some amount of NRLP's purchase power costs.
It would have in 2022. When the RER rider price was set, we had reviewed the purchase power cost of New River leading up to that. And I believe the calculations in which at that time it was estimated that the renewable energy would have been more expensive than the CPP costs were based on sound data. We all know what happened in 2022 was very unusual and large part due to global events that impacted the cost of natural gas. And so I certainly hope we don't see that again, but then there's no guarantee.
Thank you. You reviewed, I'm moving on from that exhibit, by the way. You reviewed the calculations behind the SSC, originally $6.17 per kilowatt, now $5.92 per kilowatt. That's on page 14, line 12 to 13 of your testimony.
Yes, we reviewed those. I did.
And you concluded that the value of the SSC is based on an allocation of the transmission and distribution related costs associated with the delivery of energy from the PPA that are not avoided. That's just following that section.
Yes.
And you testified that the calculation of the SSC is mainly driven by the influence of the coincident peaks on page 15, line 12.
Yes.
Were you present for witness Barnes' testimony this morning?
I was.
So valuing customer-sided solar at an averaged flat volumetric rate does not take into account the cost avoided by solar's contribution to monthly coincident peak, does it?
Well, I listened to witness Barnes' testimony, and I didn't follow all of it, but I followed, I think, a good bit of it. And I guess what I would say is that much of witness Barnes' testimony is probably technically correct, but it's very difficult to base a calculation for a value that only occurs at certain times or certain hours of the day or season or year, when, as I said before, we're dealing with average rates and costs that are averaged over a period of time. So for instance, New River, and I'll just talk about their residential rate for now, is essentially a flat rate. So every kilowatt hour is priced at the same cost, and they have averaged the cost of their system, their distribution costs, their costs that they're charged from Bremco, their transmission costs that they're charged from Duke Energy to get the power there. And they've taken the total cost and they've averaged that out into a flat rate. So while it is probably true that a kilowatt hour of energy that's produced from a solar PV system may have a different value depending on when it's produced, it doesn't change the fact that if the customer uses that to offset some of its purchases from New River, it is avoiding paying for a portion of the distribution and transmission costs with every kilowatt hour that it offsets. I mean, it's the cost that it's offsetting are not varying in terms of the rate itself.
In terms of the
The-
customer's rate?
Yes.
Okay.
So New River doesn't collect recovery of that cost, which means some other customer has to pick that up.
Wouldn't that also be true of the compensation under Schedule IR?
I believe Schedule IR is based on the capacity price from Carolina Power Partners, which is priced on a dollar per kW basis. So they literally, New River won't be making that payment to Carolina Power Partners if customers are able to help them avoid, the demand at that particular time. So that will be spread to all customers through their rates.
And
That is a cost that does vary for New River in terms of their month-to-month bill.
just to be clear, if solar contributes to meeting that coincident peak need, it would also avoid that cost, wouldn't it?
If it is generating at the time of the coincident peak, it would offset at least a portion of that cost. I would point out that, and of course, the peaks are set monthly, but New River is a winter peaking utility. So from that standpoint, they look very much like a gas LDC, if you looked at their load profile. So there's not a lot of solar production in the winter, in the early morning. I'm not saying there's zero, but there's not a lot. And if the peak is, I think one of the commissioners asked yesterday if the peak was at 4 a.m., which it may or may not be, but it could easily be at 6 a.m. In the winter. There's not much sunshine at that point in time, so you're not getting very much production out of the system. So if we had, and that's where a lot of New River's costs come from, even though they're billed to customers throughout the entire year. So if we had rates that varied with time or with season and we could match those up, there would be a stronger argument perhaps to varying the value of the solar and using that to potentially offset a portion of the SSC. But New River does not have rates that are set like that, at least at this point in time. Retail rates.
So, okay. So it sounds like I'm trying, I wasn't expecting to do this, but I'm trying to understand something. It sounds like you're implying that the value of solar has to be limited by the customer's retail rate. Is that right?
The value of solar is what it is, but whether we can recognize it or not in the way that customers are compensated is somewhat limited by the way the rates are billed. I mean, the commission several years ago with the Duke Energy and Progress Energy net metering riders required customers, well, in order, I guess they didn't require customers to be on a time of use rate, but they set certain parameters for how customers would be compensated as to whether they were on a time of use rate or not, because they recognized that time of use rates could somewhat account for the varying time value of the production. But New River at this point in time does not have time of use rates. They don't have real time rates. So there is no way to do what Mr. Barnes was advocating and there not be cross subsidization, but flowing from other customers.
Okay, I think I understand.
So let me interrupt. We're getting close. We're reaching the time for our morning break. How much longer will your cross-examination be?
I have another, I'd say, well, there isn't exhibits, maybe 15 minutes.
Okay, so let's go ahead and take our morning break now then, and then we'll continue with your cross-examination. So we'll be back at 10 minutes, 11:45. record. And before we get started again, I'd ask for all of the parties who have reserved cross-examination time that before you begin your cross-examination, to please review the estimated time. I'll provide all of the parties some leeway with their cross-examination, but do the best that you can to keep it within the time period that you have estimated. Okay, so let's go ahead and continue with the cross-examination.
Mr. McLaughlin, your testimony indicates you consider resetting of credits as one way to reduce cross-subsidization from non-participants to participants, correct? And that's on page 14, line 19 to 15, line 1.
Yes, that's the purpose of the reset, is to offset cross-subsidization.
Isn't it possible that there could be a cross-subsidy in the other direction from participants to non-participants?
I can't envision one. I mean, if you want to give me a scenario.
Such as through a combination of a very low credit rate for solar and a high fixed charge? One or the other or both?
Not sure I understand your question.
Well, let me ask this. If that were possible, the public staff would oppose it, would it not?
I'm not sure what, I don't understand I'm not sure what we'd be opposing. I don't follow your question.
Is there no, so say the fixed charge for solar customers was $100 per month. NRLP is recovering all of its fixed charges and more. And that's just what the customer is charged for having solar. Wouldn't that solar customer be subsidizing non-participating, non-solar customers?
If a solar customer were recovering $100 in fixed charges, is that what you're asking me? And then they would be subsidizing other customers?
If NRLP was charging a solar customer $100 fixed fee, that more than covered all of NRLP's fixed charges to serve that solar customer.
Well, if it more than covered NRLP's fixed charges, then yes, that would constitute a cross subsidy. But I will point out, I mean, as we talked about before, we deal with average costs, and there's no way to eliminate all cross subsidy. We're trying to minimize it. I mean, you're always going to have some customers that cost more to serve than other customers, and we're charging them one rate. And so when you do that, there's no way to 100% eliminate cross subsidy, but we're trying to not allow certain customers to completely avoid recovery of the fixed charges that they're responsible for at the expense of other customers.
Okay, but the public staff would want to, as you said, minimize a cross subsidy from solar customers to non-solar customers as well, would it not?
Sure, yes.
Okay. If there is that cross subsidy.
If it exists, yes.
Well, if there is a cross subsidy from solar customers to non-solar customers, then resetting of the credits every year would deepen that cross subsidy, wouldn't it?
I think there are two types of cross subsidies. There are cross subsidies in terms of fixed costs like wires and portions of the distribution network and the demand charges that New River has to pay Brimco and Duke Energy Carolinas for the ability to deliver power to New River. And then you have a more energy related cross subsidy, which is really what I see the reset being more related to, where a customer accumulates I will call them credits, kilowatt hour credits, when their solar system, in this case, behind the meter, we'll say a residential customer on the rooftop, produces more energy than the customer is consuming. And so they've, the word we usually use, they've banked these credits. And then when you go into a period of time when the customer's demand or usage exceeds what their system can produce, let's say in the case of New River, that would be in the winter, when the demands are the highest for their customers, mainly, I think, due to electric heating load. And then that is also a time when their costs, their energy cost, from their wholesale contract would be higher. The customer is then going to use that energy that was banked during a cheaper period of time to offset energy it is now using during a higher cost period of time. New River's still experiencing those higher costs, and they get spread to other customers. That's, for New River, this would be somewhat like a fuel charge for Duke Energy or Dominion Energy, but for New River, it's their purchase power cost. And so other customers would be having to pick up those higher energy costs. So to me, the reset and the SSC both address cross subsidy, but for some different types of costs.
Okay, but on the premise that there's a cross subsidy from solar customers to non-solar customers.
Given New River's load profile for the reset and when they proposed it, I having a difficult time accepting your premise that for the reset portion that solar or behind the meter customers could be subsidizing non-solar customers.
Okay, I'll move on. You note on page 6 of your direct testimony, lines 12 to 16, that given New River's SCADA investments, it is now positioned to begin looking into implementing new opportunities to assist customers with more energy efficiency measures, demand response, and time of use rate designs. Is that right?
That is correct.
And these measures, as you say on lines 15 to 16, could help reduce or shift overall peak demand and energy consumption.
Yes.
The stipulation does not mention energy efficiency, demand response, and time of use rate designs, does it?
It does not.
There's no commitment, for example, that New River file EEDSM, energy efficiency or demand side management programs in its next rate case.
You're correct. The stipulation does not say that. But the public staff's position for New River is as it is for other companies. We expect them to explore opportunities for DSM EE programs, and as they are able to identify cost-effective programs, that they bring those forward for commission approval. So that's an expectation we have for all utilities in North Carolina, and that hasn't changed in this case. So, and I believe witness Miller has stated, I believe in his rebuttal testimony, that New River is pursuing some grant opportunities. So I would certainly encourage them to continue to pursue that and other opportunities.
But you would agree the public staff is in no position to guarantee that it will do that?
No, we can't force the company to.
Okay, no further questions.
And I believe that New River had reserved potentially the opportunity for cross-examination. Do you wish to cross-examine Mr. McLaughlin?
Yes, please. Mr. McLaughlin, you were asked about the volatility of purchase power cost from CPP, as those costs reflect changes in gas prices. And you were asked about renewables not having volatility. When you look at the cost of electricity for New River, purchased electricity, including during peak demand times where firm or reliable power is needed, on average, over time, is the power from CPP going to be more or less expensive than, say, displacing that entirely with renewables?
With that requires some speculation, but as I believe I said on the earlier cross, at the time that the rate was set for the renewable energy rider, we were expecting that the renewable energy, the cost for the renewable energy power would be more expensive than the cost for CPP, and that was based on the data we had at hand. And in a normal year, I don't know that there's anything that would have changed our mind about that. So we would stand by our position. The public staff would, and I personally would stand by our position when the renewable energy rider was originally approved by the commission, what the costs that were used to back that up.
And you alluded to global events in 2022 that affected that volatility. Were you referring primarily to the invasion of Ukraine by Russia?
Yes, and the cost of natural gas due to U.S. exports of LNG to Europe to help meet the demand there due to Russia cutting off their supply.
Was that foreseeable?
Not by anyone that I'm aware of.
You were asked a number of questions about flat volumetric rate versus using peak demand costs for the value of solar. Is it your understanding that under the NBR proposal that solar would energy provided by customers to the New River grid would be valued at the retail rate that New River charges?
Yes.
Okay. And looking at the summary provided by witness Barnes, I'm just going to read off of page 2 of that rather than have you dig it up. There's a sentence that says, first, the commission should eliminate the SSC because my analysis, which corrects more errors in New River Light and Power's evaluation, indicates the value of residential sited solar generation slightly exceeds the residential retail rate. Now, regarding that and the questions you received, does the public staff believe the standby charge should be eliminated?
No, we do not.
If it were eliminated, in your opinion, would that result in non-participating customers subsidizing the solar customers?
Yes, it would.
Thank you. That's all my questions.
Redirect.
Mr. McLaughlin, in cross-examination from App Voices and from the company, you've kind of been asked about the interplay between SSCs and cross-subsidization. So can you, I wanted to give you the opportunity to just explain how, in your opinion, an SSC helps avoid cross-subsidization between participating and non-participating customers.
Okay. And let me start off my answer. I'm not sitting here saying that I think the SSC that is proposed by the company is a perfect charge. I don't think perfection is even possible in this situation. So that it's not my testimony that $5.92 is the absolute perfect number, but it is my testimony that it is appropriate that there be a charge of this type to avoid cross-subsidization. And I have reviewed the calculation for that, and it is based on what I believe is sound data. It is reproducible and verifiable. So I just wanted to be clear on that on my testimony. But the SSC is made up of different components that of cost that are real cost to New River, which their customers have to pay for through rates. Whether it be for the investment in New River's own distribution plant or the charges it receives from Brimco for wheeling power across their system, or the transmission charges that Duke Energy Carolinas charges for wheeling the power from CPP across their system. So those are very real charges. To the extent that the behind the meter generation is not offsetting those costs or not completely offsetting those costs, there will be a certain level of those costs that will be avoided by their generation, but will have to be picked up by other customers and that do not have behind the meter systems, and that constitutes cross subsidization. And that's something that we know is there, and that has been an issue with net metering rates throughout their history. It's been a concern of net metering rates throughout their history.
To your knowledge, are there any charges that are contained in the SSC that are also duplicated in a basic facilities charge for the company in this case?
The basic facilities charge is designed to pay for a portion of the cost of not only the customer's meter and the service drop leading to the customer's home or business, but also a portion of the distribution cost. In the SSC, there is also a portion of the New River's own distribution system cost. And I heard some questions yesterday. I believe Commissioner Clodfelter was asking that. So I went back and I checked the calculations again to make sure that I was satisfied that there was no double dipping in effect. And so the portions of the distribution system, based on my analysis, that are recovered through the monthly basic customer charge are not included in that portion of the distribution costs that make up the SSC charge. So there should not be any double dipping.
And wanted to turn to some questions that you were asked about the resetting of solar credits or energy credits. And your response was, to my recollection, also related to prevention of cross subsidization. So I wanted to give you the opportunity to expand on that cross subsidization and then also give your opinion whether some form of resetting is necessary to ensure that cross subsidization does not occur.
Yeah, whenever, and this has been the public staff's concern. It's been a concern of this commission in the past in their orders. Whenever energy is produced and banked during periods of low cost, and then the customer is able to draw on that during higher demand and higher cost periods, they're still placing a demand on the utility to go out and secure that power, but they get to offset their costs for it with the lower cost energy that they banked. So those costs are still, they're very real and they're still there. but because the net metering customer is offsetting part of their usage with the banked energy, then the other customers who aren't net metering customers have to pick that up and pay for that. So that causes a cross subsidy. And so that's why the resetting is important. Now, in the Duke Energy net metering, riders and the commission issued the order, I believe it was E100 sub 190. We now have a monthly settle up. So if there's any excess, it doesn't carry over from one month to the next, and the customer gets essentially gets paid for that excess at some type of avoided cost. That is my understanding, is that is not something that New River's system, their metering and billing system can handle that. And it's certainly at this point in time, I'm not saying they can't in the future. That would be an alternative to having like an annual reset, but that's not something that's available right now.
And in your opinion, does the annual reset that's been proposed to reset the energy credits in this case, is it sufficient to address the cross subsidy issue that you just discussed?
Well, and as I said, it's sufficient for it. That doesn't mean it 100% offsets it, because as I said, it's impossible to design perfect rates.
No further questions from the public staff.
Okay, thank you. Mr. McLaughlin, I'll begin. And let me step back and just ask you a question that you haven't talked about yet about service from New River. Have you, I assume that the public staff attended the public hearing and also has done an investigation about service. And can you describe efforts to improve service from New River and public staff's position about adequacy of service?
Well, certainly the public staff has received no concerning level of complaints from customers about the service level they're receiving. I did not hear any concerns at the public hearing. I was at the public hearing as you were. Most of the witnesses that appeared there were talking about the net metering issue. I believe there was one witness that commented on the targeted undergrounding that New River has done in some neighborhoods. And certainly the service quality indices that were provided by New River are satisfactory. So as far as I'm concerned, I believe the service they're providing is adequate.
And then one of the topics about the SSC that we haven't touched on very much is about what it should be based upon. And we have, I'd like to hear the public staff's position. Appalachian Voices believes that it should be based upon the system design capacity, and then New River has done it based upon inverter nameplate capacity. Can you talk a little bit about what the public staff's position is about this issue that relates to the MBR and public staff's support of that schedule and the stipulation?
Well, I mean, I won't dispute Mr. Barnes' testimony. It could have been calculated on the system design capacity, and perhaps that would be a more accurate calculation. I have not had an opportunity to have discussions with other parties about that. I mean, it's a denominator. Ultimately, you're dividing something into a level of costs. And I don't know that using the nameplate capacity is a bad way to do it. As I said, it may not be the absolute best or most appropriate, but I don't think the public staff would not have a problem with exploring a more appropriate way, although we are satisfied with, at this point, with the calculation. That's one of the reasons we recommended that this be reevaluated by the commission at some point in the future. And I believe our testimony and the stipulation says 5 years. If the commission felt that it should be more frequent review than that, then I'm sure the company, the public staff would work with that. I think it's important to remember this is New River's first attempt at a true net metering rider. And so they're going to learn a lot from this and what their system is capable of handling. And I think what they proposed is a reasonable attempt at implementing that at this time. Again, not testifying it's perfect and not testifying that it can't be made better.
And that kind of leads to my next question about what's been recommended in the stipulation is a review in 5 years. And I think you heard witness Barnes, who testified that he objects to having the MBR schedules in place and a review in 5 years because he believes that customers will be overbilled during that 5-year period. And you've already touched upon this, but can you state very succinctly for the record about public staff's position in regard to overbilling if the review occurs in a 5-year period?
Well, we don't have retroactive rate making, so we don't rebill customers on anything that I know of, except perhaps fuel and maybe a couple of other riders that we try to true up if we find that there's been an overbilling or an underbilling on an annual basis. I would again say that I view this, that the charges that are included in rider NBR, I believe, are reasonable and are based on sound data. But we'll go back and reevaluate that at some point in the future, either 5 years or whatever time period the commission feels is most appropriate, and we'll adjust that if and when we find that there is something that is more appropriate.
So I guess just to ask you very directly about this, is the public staff have real concerns or significant concerns about overbilling then?
No, not at this point in time. If we did, we wouldn't have entered into the stipulation if we had serious concerns about overbilling.
And then about the basic facilities charge, the public staff did not contest New River's proposed increases to the basic facilities charge. Can you explain why the public staff took that position?
Okay. Well, New River's analysis was essentially the minimum system approach, and they identified a cost of about $36 is what could be justified. Minimum system is what has been used by other utilities in the state and approved by the commission. And so we didn't take issue with their use of minimum system. They did have an increase in the charge, I believe, for Duke Energy Progress, Duke Energy Carolinas, and Dominion. I believe their basic facilities charge is $14 or right around that. So our evaluation, New River technically could justify a higher charge. The charge they proposed was in the ballpark of what other utilities in the state are charging that are regulated by this commission. So we did not have any concerns with it.
And just for correction or clarification with the record, it was the modified version of the minimum system method, correct?
Yes.
Okay. And then along those lines, New River's witness Hallie states that this modified version of the minimum system method is more in line with North Carolina utility regulation than the approach that's been suggested by Appalachian Voices witnesses. Does the public staff agree with that position or that statement, or disagree with that statement? You've sort of answered it already, but I'd like to hear a direct answer to that question.
Yeah, I think my review of Appalachian Voices witness was that they used or they preferred the minimum customer method, and they were coming up with a lower charge, although I believe they did go back and attempt to make some adjustments to the modified minimum system. But we're really, now we're talking like $1 here at $1 there, and I don't mean to minimize cost, but we're sort of splitting hairs at this point, and we did not see any significant reason to take issue with the company's proposal.
And then just a couple of questions about the reset, the annual reset for the MBR schedule. In New River's rebuttal testimony, their witness has stated that that they would agree to eliminate, to go along with Appalachian Voices' recommendation of eliminating the annual reset. And then in the settlement stipulation, the annual reset was included in what was agreed to between New River and the public staff. And you've talked quite a bit already about that annual reset. Is the public staff's position that that it absolutely that we must have this annual reset to prevent cross-subsidization? Is that something that's critical for the stipulation that you entered into?
The short answer is yes. And I testified that I believe the proposal by New River meets the requirements or the policies that are outlined in 589 for net metering. Of course, I said it's up to the commission and the legal experts to decide if New River has to comply with 589 in terms of net metering. But certainly that was the basis or one of the bases we used for evaluating NBR. And 589 requires either, I don't have it in front of me, it's either minimization or elimination of cross subsidy. And so we believe that it is absent some other way to account for the cost of energy from one period to the other that I described earlier, and I won't go back into that. We believe that the reset is essential.
Okay. And then my last question is related to Appalachian Voices witness Barnes's testimony. He of course believes that there should not be an annual reset, but he said he says if there is an annual reset, he disagrees with it being on January the 1st, and he proposes that the customer should be able to choose the reset period. What is the public staff's position about having a reset period that the customers could select rather than a standard January the 1st reset period?
Well, I'm going to give you an answer, and I don't want to disparage customers because they're going to act for the most part in their best interest, as most people do. If they were allowed to pick when the annual reset occurred, perhaps they might pick some time coming out of the winter when there was no excess bank of energy, and then it wouldn't help offset the cross subsidization issue. So in my opinion, it is appropriate to have the reset at a period of time when there's been a significant bank of energy at low cost that has built up prior to moving into a period of high cost. If the commission, I'm sure, remembers that for Duke and Progress, The reset was on June 1st. At that time, when that was established, that was when they were summer peaking utilities, and you had had a significant bank of energy build up over the spring, which was a lower cost, lower usage period of time. And then you were moving into the summer, which was a higher demand due to their air conditioning load and higher cost. And that was why it was determined that it was appropriate for them leading into the summer. Here with New River, you have a heavily winter peaking utility. So I believe I don't know if January 1st is the absolute right, but it should be sometime leading into the winter period.
Okay.
So.
Okay, thank you. Chair Mitchell?
All right, Mr. McLaughlin, I won't, just a few for you. We talked some, you've testified today about volatility with respect to gas prices, and I understand the volatility that we've experienced over the past couple of years and reasons therefore, so we don't need to cover that ground again. But what can you tell me about, to the extent that you know, any mechanisms in the contract with Carolina Power Partners to reduce volatility in pricing or otherwise protect customers from volatility in gas pricing?
I am afraid I am not intimately familiar or prepared today to discuss the wholesale contract with
Okay.
Carolina Power Partners.
Okay, and I'll ask Mr. Hinton the same
Apologize.
question, see if he has anything to share.
He may know more than I.
Okay. Are you sure you want to admit to that? I'm kidding.
He would tell
that's a
you he
joke.
does anyway.
I'm sure he would. All right. So, I mean, typically, the reason for my question is, you testified that a majority of the power supplied to New River comes from the Kings Mountain facility, which is a natural gas fired facility. So there's not a lot of diversity there, fuel diversity with respect to the electricity that's being provided to customers. And so I'm just concerned about sort of dependence on that single source of electricity and implications for customers. So,
The public staff shares those concerns.
okay. What do you know about Kings Mountain's performance during Winter Storm Elliott? If anything.
I know some things, but I think what I know is confidential.
Okay,
So
fair.
I
Don't-
don't think I'm allowed to say.
That's fine. What do you know about backstanding of Kings Mountain? Who backstands? Let me ask my question this way. Does New River have a source of backstanding supply?
Well, I know that for Kings Mountain, if they are unable to generate, they are required to go out and secure power. So to back them up. So to that extent, New River is I don't know all the details of Kings Mountain's backup supply guarantee, but obviously it's one plant and they can't operate 365 days a year. Even if it doesn't break, it's going to have to come down for maintenance at some point, and there's still going to be a demand from their customers, so they have to go out and secure that power.
Okay, so make sure I understand you correctly. The backstanding obligation rests with Kings Mountain and not with New River Light and Power.
That's the way I understand it,
Okay.
yes.
And do you know anything about where Kings Mountain is? How is Kings Mountain seeking backstanding service?
I don't know. I assume they work with other power marketers, or they have their own power marketing.
Would you know?
But I don't know.
Okay.
I don't know.
And I understand, and I won't press you there, but if I will ask you this one question, and if your answer is, I don't know, that I understand. Is Kings Mountain backstood by Duke, DEC?
Well, they would be for a period of time. I mean, if the plant trips, they're not going to immediately have somebody waiting in the wings at that instant. And so Duke would be the backstand party, but I believe usually the NERC requirement is within 15 minutes, they would have to have some other source of power. And
Okay,
it could be that they would get to cover that for a period of time, but I don't, I'm speculating a little bit now.
and I understand. I'll accept that your testimony is speculation. And then do I understand your testimony to be that federal law or federal regulation obligates DEC to backstand new Kings Mountain, the Kings Mountain facility?
I don't know that federal law requires it. I mean, it just by the laws of physics.
Okay, I wanted to make sure I understood what you were saying. So you're saying
I-
the electrons are going to flow and they're going to come from DEC.
Because they're the closest
Yeah.
source of power, but
Okay,
what
got it.
what the contract or the terms they have literally say on paper, I don't know.
okay. All right. Thank you, Mr. McLaughlin. I appreciate it.
Yes, I just want to go back for a minute on the annual reset and the stipulation, and that it's to be reviewed in 5 years at this point. Mr. Barnes testified that one of the concerns, kind of, if you can separate it from the overbilling, was just that because of that overbilling, I guess, that the subscription may be less during this 5-year period because of whatever realities the customers are experiencing and perceive about this, about, what's happening and the value and benefit to them. Is that lack of lower level of subscription, if it were to develop, if that is something that you see occurring within that 5-year period, is that something that's worthy of consideration? And what's the public staff think about that as one of the issues?
You mean at the 5-year review, would that be worthy of consideration then or now?
Now, I'm asking, now, should we look at that? What's the public staff think about that in terms of if sooner than a 5-year period, if we were seeing that there was a low subscription?
Well, like I said, earlier, if the commission feels that it ought to be looked at earlier than 5 years, then that's your call. 5 years was the settled number. And so as to the other part of your question, I mean, I'm not an expert in net metering system economics. I will agree that the $5.92 is a high charge. No, you asked about the reset. I'm sorry.
You're asking about
The reset. Sorry. We certainly know from past history with the Duke Energy Carolinas and Duke Energy Progress customers, they don't like the reset. I can't tell you how many complaints we've had from customers, but they've still installed net metering systems. Now, I know many people would argue we don't have enough net metering systems, but it has grown significantly over the last few years. So it has not kept customers from installing. Maybe it has limited the number of customers that are interested, but it certainly has not stopped it. And it is, the concerns are valid about what would happen without a reset. And, in terms of the cross subsidy.
Right. And if I guess I'm asking if we saw before the 5-year review that the annual reset was having an impact one way or the other, is that something that the public staff would think significant or think worthy of consideration now as we sit here to make that decision?
Well, since we've entered into a stipulation with the company, and if, assuming the commission accepts the stipulation, it would be something that I think both parties would have to agree to, but, we would be willing to engage in discussions with the company about that.
What would you think about it, just in general, outside the stipulation, though? Is it, I'm just trying to get at, is it, I think Commissioner Camerate used a phrase earlier when she was asking about the overbilling, and I'm asking about the other piece, but is it significant, insignificant, you know? Or would you just default to it's reasonable at this point?
I guess it's one of those things where you would consider it at the time. I mean, it's hard to know exactly what motivates a customer to install or not install a system on their roof. Is it, if they don't, is it solely because of the reset? Is it solely because of the SSC? Is it solely because some other costs of the system or equipment have increased? It's, at this point, it's hard to just single out this one thing and say, well, if net metering, if New River doesn't have a 200% increase in net metering within 5 years, it's all because of the reset. I don't know how to put a weight on that or percentage on that. So
Thank you.
Mr. Duffley?
So good afternoon. I had a question about the reset as well, and just some clarification of your testimony or what I heard, and to make sure what I heard is what you said. So you stated the annual reset right now is in beginning of January.
January 1st, I believe.
And did I hear you say that because this is a winter peaking system, that it might be more appropriate to have that reset at a different time period?
I said it possibly because I consider December a winter month, even though I guess technically winter doesn't begin until December 21st. Maybe a reset would have been more appropriate on December 1st, but definitely in the winter time frame.
Okay, so but not August or September.
No,
You're thinking
no.
December
Yes.
might have been.
So-
So just a month
Heading into the winter.
heading into the winter. Got
Yes.
it. Okay, thank you for that. And then my one other question, you discussed that the stipulation does not require EE and DSM. If the commission wanted hypothetically to encourage EE DSM, does the public staff have any suggestion of programs, or would the public staff think that New River should suggest those programs?
I think New River is the only entity that knows what their costs are and could evaluate what it would cost to implement those programs. I think it's perfectly appropriate if the commission wants to make suggestions for New River to evaluate. I think Witness Miller has said they are pursuing grants for high efficiency heat pumps and water heaters and programmable thermostats. And I believe they're also possibly looking into some weatherization programs. But again, we would want those programs to be cost effective, and two things are working against New River. One, they're very small, and so they don't have a large customer base. There's going to be a certain level of overhead or fixed cost associated with any program, and they don't have a large customer base to spread those costs. And number two, I think about 3/4 of their housing units are rental properties, meaning they're not owner occupied. That's not what, they're not, whoever is occupying does not own the facilities, like, sort of like multifamily. And I know the commission is aware of even some of the difficulties that larger utilities have had with multifamily programs. And because the person who's making the investment, the landlord or the owner, is not the same person who's living there and getting the benefit out of it. So certainly we don't want to just write it off and say there's nothing that can be done, but I would really caution against mandating that New River go do certain programs until they've had an opportunity to investigate the costs and report those back to the commission.
Okay, thank you for that.
So Commissioner McKissick, before we get started, we do need to take our lunch break no later than 12:45. So if you can complete your questions by that time, you can go ahead.
Follow up on the question Commissioner Duffley was asking about DSM and EE. To what extent did the public staff work with New River to evaluate some options that might be plausible given the limited size of the customer base? It was about 4,400 customers or so, and and given the their peculiar financial capacity. Okay, I mean, were there options evaluated? Because I understand your last remarks as well, and I read similar remarks, in documents related to the case, because it's an area that, I think needs to be thoroughly investigated and explored. So, I mean, how far did you go down a pathway with them, or to what extent were their discussions held?
In this case, I would say not extensive discussions. We have talked with them in the past, and certainly, as was pointed out, that there were, in the stipulation in their last rate case, their stipulation with the public staff, they made a commitment to evaluate programs in particular that they could take advantage of their AMI metering to offer those. The conversations that we have had with the company have been, they are still evaluating. Of course, they just got the SCADA system, the new SCADA system implemented that they said was important to offering not only DSM and EE programs, but looking at some time of use rates. And so I guess the public staff is still waiting for the company to come back to us and say, this is what the results of our investigation have shown. We have not pressed them to a great extent on that at this point, but we will continue to have conversations with them, is what I would say.
And is there a reason why they haven't been pressed more than what has occurred?
Just understanding some of the difficulties that they face, but if the commission would like for us to be more aggressive with the company in pursuing those, we will certainly be happy to do that.
Sure. Thank you, sir.
Okay, let's go ahead and go off the record. So we're going to take our lunch break, and we will be back. I'm trying to keep everything moving along as quickly as possible. So we'll take 1 hour, which we'll be back at 1:40. And I've also looked at the cross-examination times. It looks like we have about an hour and 20 minutes of cross-examination time going forward. So our goal is to finish by mid-afternoon today, and I think we can do it. So I would encourage all of the parties to be as efficient as possible with their questions and to stick to the cross-examination times. And then, of course, there will be commission questions, but we do need to be efficient as we go forward this afternoon. So we'll come back at 1:40. And let's go back on the record. Before we get started with questions on commission questions, I have looked back through the cross-examination estimate times, and unfortunately, I think my math was wrong because I missed some cross times. I recognize that it may take a little bit longer than I had expected before the break. That being said, we are going to finish today. We always finish at 5 o'clock in the afternoon. So I would urge all the parties to be as succinct as they can be, because we need to finish today. We do not have, finding a time to come back would be very challenging at this point based upon the commission schedule. So we're going to work very hard to be done by 5 o'clock today. Okay, so let's go ahead and get started, beginning with questions on commission questions. Ms. LaPlaca?
I have none.
Okay. Appalachian Voices?
No questions.
New River?
Very briefly.
Okay.
You were asked about the proposed, the 5-year review of the MBR rate that's in the settlement. Given what you know about the size and resources of New River Light and Power, would it make the most sense to do that type of review within the rate case context, as opposed to hiring consulting firms and all the time that goes in and trying to attempt that outside of a rate case?
We certainly would like to minimize the expense on New River and their customers, but of course I don't know how long it would be before you would be back in for another rate case. So I would want to at least keep it no longer than the 5 years, even if you're not back in for a rate case.
So it'd be reasonable to say 5 years or the next rate case, whichever comes first?
That would be fine with me, if that's agreeable to all other parties.
That's all I have. Thank you.
Just one question, in response to the line of questioning from both Commissioner Duffley and I believe Commissioner Kimmerite on the resetting of solar credits annually. Mr. McLawhorn, I'm trying to channel Jack Floyd as best I can here. Would you agree that the cross subsidy issue that you discussed in terms of the annual reset is also an affordability issue, to the extent that that cross subsidy would be occurring from those who potentially cannot afford to install rooftop solar, subsidizing those who can afford to do it if there was no such reset?
Yes, I should have mentioned that earlier. That has always been one of the public staff's concerns of customers who cannot financially afford to make an investment of that type, having to subsidize customers who can.
No further questions.
Thank you. So I'll hear motions from the parties now.
Thank you, Presiding Commissioner Kimmerite. At this time, I would move that the appendix and exhibit attached to Mr. McLawhorn's pre-filed testimony be entered into the record and marked for identification as pre-marked.
Okay.
And I believe that the testimony was already addressed with the previous motion.
So seeing no objection, your motion to have the exhibit admitted into the record is allowed.
Thank you.
Mr. McLawhorn, thank you for your testimony, and you may be excused.
Thank you.
Public staff may call its next witness.
Thank you, Commissioner. The public staff calls John Robert Hinton.
Good afternoon, Mr. Hinton. And if you'll place your left hand on the Bible and raise your right, and do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Thank you.
Thank you, Commissioner. Mr. Hinton, would you please state your name, business address, and title?
My name is John Robert Hinton. My address is 430 North Salisbury Street. Raleigh, North Carolina, and I'm the Director of the Economic Research Division for the Public Staff.
On June 6th, 2023, did you cause to be filed in these cases pre-filed direct testimony consisting of 34 pages, 2 appendices, and 12 exhibits?
Yes.
On July 6th, 2023, did you cause to be filed in these cases pre-filed settlement testimony consisting of 7 pages and an exhibit? And I know the settlement testimony made certain alterations to your pre-filed direct testimony.
Yes, I did.
Mr. Hinton, if you were asked the questions set forth in your pre-filed direct and settlement testimony as the settlement modified the direct, would your answers as altered be the same today?
Yes, there's one change I'd like to make.
Oh, please.
My pre-filed direct testimony filed on June 6th, on page 11 of my testimony. On line 8, the word decreased should be increased.
Okay, then let me re-ask you, with that change, now, would your testimony be the same today as in the changed testimony as altered by the settlement testimony?
Yes, it would.
Thank you. Presiding Commissioner, at this time, I move that the pre-filed direct and settlement testimony with the correction by Mr. Hinton be entered into the record and the transcript as if given orally from the stand, and that Mr. Hinton's 2 appendices, 12 direct testimony exhibits, and single settlement testimony exhibit be marked for identification in the same manner as they were when pre-filed.
So Mr. Hinton's direct testimony filed on June the 8th of 2023 consisting of 34 pages, and his settlement testimony filed on July the 6th of 2023 consisting of 7 pages will be copied into the record as if given orally from the stand, including the correction that Mr. Hinton just testified to. The 2 appendices and the 12 exhibits attached to Mr. Hinton's direct testimony and the 1 exhibit attached to his settlement testimony will be marked for identification purposes as pre-filed.
Thank you very much, Commissioner. At this time, Mr. Hinton is available for cross-examination and questions from the commission.
And from the information that I have, the only cross-examination of Mr. Hinton is from Appalachian Voices.
Thank you, Commissioner Camerite. Good afternoon, Menashe Magruder, co-counsel on behalf of Appalachian Voices, just for the record. And I'll try to cut down on this a little bit. Mr. Hinton, good to see you. So the public staff originally proposed a rate of return of 6.07%.
Yes.
And that rate of return was based on a ROE, so return on equity of 8.9%, cost of debt of 3.23%, and 50% equity to 50% long-term debt capital structure, correct?
Yes.
Now, in the stipulation, of course, New River and public staff have agreed to a new overall rate of return of 6.165%.
Correct.
And that rate of return is based on an ROE of 9.1%, cost of debt of 3.23%, and that same hypothetical capital structure, so 50% common equity to 50% long-term debt.
Yes.
Okay. So you filed some testimony supporting the cost of capital and usage adjustment provisions of the stipulation on July 6th. Is that right?
June 6th, yeah.
June settlement testimony?
No, so you're right. Forgive me. I had my dates wrong.
All right. Yeah, no worries. Do you have that testimony in front of you right now?
Yes.
When you're there, can you turn to page 4, lines, I think it's, so I have the site right. It should be lines 58 through 59.
Yes.
Can you read that out loud into the record?
From 58 to 59.
Yeah, on page 4 of your settlement testimony.
The company and the public staff have fundamentally different views on current marketing conditions and the current cost of capital.
Okay, thank you. So obviously recognizing there's a stipulation in effect, would it be fair to say that it's your position that the public staff's original 6.07% rate of return proposal is reasonable.
Yes, it's very reasonable.
Okay. All right, moving on. So generally speaking, a return on equity should compensate a utility shareholders for foregoing alternative investments in comparably risky companies.
That's the major principle of.
So basically, when we're thinking about that, the utility shareholders, they have an opportunity cost that's got to be compensated through an appropriate return on equity.
When you're talking about publicly traded companies, yes, that's exactly the case. That definitely does not directly apply to this case, though. And we can go further than that if you'd like to, but in my opinion, the methods I've used to come up with the opportunity cost of capital still apply.
Okay. And just to confirm, I mean, obviously you've already kind of predicted where I'm going with this line of questioning. New River ultimately is an operating arm or division of Appalachian State.
I noted that in my testimony that any decision on the riskiness of this company and needs to consider that. And I believe I have testified that that's my position. I believe that is the case. And I've tried to adjust my recommended return on equity with that in mind.
Okay. Again, sort of touched on this already, but just to kind of make sure that we're getting this into the record, ultimately New River's capital financing needs, specifically their needs, how they finance their capital, that's going to be satisfied through debt financing and their retained earnings.
Largely so. I'm sure that's how the company over time does that. It's like any other company. Again, they're not an investor-owned utility. If you own, it's accept and understand that investor is actually the state of North Carolina. And a simple point I'd like to get in the record now, because it may be the best time to do it as such, is that even though it's owned by the state of North Carolina, I don't believe that Mr. Hoyle's recommendation of a 6%, 6.25 return on equity is appropriate for this company, because he recognizes as the return on equity is, in his mind, I believe, equivalent to the cost of debt. I don't see that. The company needs a return, call it an equity cushion, a generator of spare funds available to handle such things that we've recently seen with the cost of natural gas. And the price of purchase power went up doubled from 4.25 or whatever to over 9 cents per kWh. They had to use borrowed funds to pay for their power. Similar when they went through a substation, they had to raise a general revenue bond through Truist to finance that substation and yard. So that's large capital expenditures. They still have to do that. They still have those operations, and they have to finance such things, and they have to keep a debt service ratio like 1.25 with their Truist lines. But they also have an opportunity cost. And here's the concept, and I don't want to get too theoretical here, but it's still an asset. It's still a regulated opportunity. It's a business. They could sell that business tomorrow. Brimco, which is a nearby cooperative, has this arrangement where they actually serve the hospital, and the hospital is located in the town of Boone. When we went on our tour of facilities, I saw a hospital, nice new big addition, a serious amount of power load that they would love to serve, but through whatever reason, contractual reasons or arrangements, it's served by Brimco. The point I'm bringing that up is that Brimco is probably a ready and able buyer, willing buyer of this service territory. So is Duke Energy. If they can't make their risk-adjusted returns on equity, Mr. Jameson would maybe be wise to tell the Board of Governors, maybe we can sell this utility, invest proceeds in a trust, and continue to fund our endowments and other funds at a more handsome rate without taking the risk of operating utility. So they still have an opportunity cost. They could sell this company if it doesn't generate the returns that are equivalent for its riskiness. And I believe the only way to appropriate the risk-adjusted rate of return is in my testimony, as I've identified using a DCF and risk premium analysis.
Of course, there's no proposed sale obviously being contemplated by New River.
That's correct. And as you asked me, investors look at the opportunity cost of capital. An opportunity cost does not necessarily depend on the actual transaction. It is, again, a theoretical cost. It's what divides accounting and economics is largely the concept of opportunity cost. Because an accountant would say X, but an economist says Y. And the Y is based on opportunity cost of the next best opportunity of that capital. And one could construe that if this utility does not earn its required return on equity, that it too would be better off being sold.
Understood. Let's go back to something you said earlier, and I think we're in agreement here. Obviously, at the end of the day, any cost of capital analysis is going to have to in some way account for New River's unique status as a state-run utility. Obviously, the parties are in disagreement as to how you would do that, but you've got to account for it in some form or fashion.
I agree with you. I said that in my testimony, that it's a fact that you need to recognize.
Would it be fair to say that the main way in which your cost of capital analysis accounts for this unique status is true? And I'm quoting you here. This is the bottom of page 27 of your direct testimony. It's around line 17. And I'll just direct you to it. I'll just read it out loud. In my opinion, these factors justify an allowed return on equity that is at the lower end of the range of reasonableness. Is that fair?
Yes, that's fair.
Okay. However, your DCF analysis and your regression analysis revealed that 8.49% return on equity, and I'm referring here to page 27 of your direct testimony, lines 3 through 5. So just if you skip just further up there, your DCF analysis revealed that the reasonable range includes 8.49%. Is that right?
And I'm sorry, you're on what page are you reading that from?
Same page, 27, lines 3 through 5. So it should be the same page that you're on. Yeah.
I'm embarrassed.
It's your direct testimony.
I know, but embarrassed. I'm missing some reason 27, 28 pages. May I borrow that? Yes. Could you repeat your question? I'm sorry.
Yeah, no worries. So again, this is lines 3 through 5.
Yeah.
You would agree that 8.49% return on equity would be within that sort of band of reasonableness.
Well, I'm not saying it would not be unreasonable what you just said, but also I had a risk premium analysis that said 9.76 was a reasonable estimate for the cost of equity.
Understood. So if you could indulge me a little bit, and I'll be brief, I just want to go over sort of the basics of the discounted cash flow analysis just real quick. So at bottom, what the DCF analysis seeks to do is it seeks to determine how much money an investor would make from an investment in the future, adjusting for the time value of money. So basically, fundamentally, as I understand it as a lawyer, it's this idea that money that you've got in your pocket today is worth more than money that you'd have at some future point. So you got to adjust for that. Is that?
Well, you do have to do the present value. That's what you're getting at.
Yeah.
But I think another way to look at the DCF model, it looks at it by using dividend yields plus a growth element. You can estimate the required return on equity for someone to give or invest into a utility stock, forego that consumption of that stock, forego investing in other stocks. And that's the rate of return that he does that with the expectation of receiving over the infinite time horizon.
Gotcha.
Long term would be the practical speaking.
Gotcha. And so for purposes of this proceeding, when you're doing cost of capital analysis, the return that you're sort of thinking about with regards to, what that stream of money would be in the future, for purposes here, it's going to be that future stream of dividends that you would get. Is that right?
Yes. I mean, that's how the model works. And yes.
Okay. And so when you're running that analysis, at least initially, what you're solving for is the price of that stock, at least initially. Is that right?
Well, that's a part of the dividend yield. You basically do a dividend over the next 12 months divided by a price plus a growth rate. And that gives you a rate of return that you think equates to the cost of capital.
Right. And so you pretty much jumped right to where I was going to go. And I will, so as I understand from what you said, when you're solving for the cost of capital, which is K in that DCF analysis, what you want to do is you want to divide expected dividends per share by the price, and you take that value, which you refer to as dividend yield, and you add the growth rate to that dividend yield. Is that right?
Yes, to get the expected return.
Right. So it'd be improper to add that growth rate to the price in the denominator. You'd add it to the dividend yield as opposed to the.
Correct.
Okay, perfect.
And as I've, yes.
Okay. All right, let's move on. So page 22 of your direct testimony and exhibit 4 of your direct testimony, you provide the peer group and the factors you use to identify that peer group in calculating your return on equity.
Yes.
Okay. So you use, and let me jump there for my own benefit. Just bear with me real quick. So you use a couple of, actually it's 4 factors. You use safety ranks, I'm probably mispronouncing it, but beta coefficients, earnings predictability rank, and the S&P bond rating.
Correct. They're widely available investment risk metrics.
Gotcha.
That I believe investors look at. Now, it's always a hard to know for sure what is the metrics that they construe in their minds when they develop their own investment expectations on risk and return. But I believe these are good indicators of risk.
Gotcha. But again, New River has, outside financing, but it doesn't issue stock.
That's true, but at this point, I just want to say briefly that the use of a comparable group for a company that does not trade stock is I hate to say it, nothing new under the sun. My first case, which was Heinz Telephone back in 1989, I believe, or 87. It was not traded. It was owned by the Alltel Corporation, but it was not traded. No, it was independently owned. It was later bought out by Alltel. But at that time, I had to use a comparable group of telephone companies to develop a comparable cost of equity for Heinz, as I'm doing here today for New River.
Gotcha. All right, let's skip a little bit. So on page 27 of your direct testimony, again, beginning on line 8, you state that New River confronts operational risks similar to a distribution-only electric utility.
Yes, one of the things I did is I went back to about 10 years of annual reports and I looked at their costs for fixed investments and their standard operating expenses and their net income and tried to do the ratio analysis on how that's been growing. Their customer growth is growing at a little less than 2% per year. There's some growth there in that company.
So another thing that you did, and this is exhibit 7 of your direct testimony, you provided a list of allowed ROEs for distribution-only utilities. Is that right?
Yes, I did.
Okay. But the peer group that you use for your sort of core analysis, that peer group includes some vertically integrated utilities. Is that right?
Yes, I think they all are. The problem there is there's not any actively traded companies that are pure play in the sense where they're just distribution companies. So I was limited on where I could look to employ the DCF model. So one could argue that the DCF model could possibly overstate the cost of equity because it's looking at vertically regulated ones, which are more risky than distribution companies, and I accept that. But I believe that if there is any overestimation, it's within a margin of error that I think my judgment kind of has that in mind.
Okay. Moving on, and your DCF analysis in calculating specifically, I think a number of things, you rely on sort of dividends, as we mentioned at the front. We sort of said, when you're thinking about DCF analysis as you've conducted it, we're thinking about stream of dividends, right?
Right. You have to use, the Gordon model calls for expected dividend in the next 12 months, and Dialine will publish in their summary editions the expected dividends for each stock over the next 12 months. So I just grab that number off their summary reports. Yeah. Okay. The Gordon model for the DCF requires the dividend yield to be the expected dividend yield over the next 12 months. And Dialine Investment Survey prints out every week in their weekly summary edition. And so I just grab that, as I mentioned in my testimony, and it's an expected dividend, because as you know, dividends, depending on the timing of when they're issued and increased by companies or decreased by companies, can affect the 12 months. So I look to, rather than, there are other ways to make that adjustment to get a D1 expected dividend yield, but this seems to be a very straightforward method that I use.
Yeah. But again, New River doesn't have equity investors, so it doesn't issue dividends.
That's correct. I mean, it does pay the endowment fund and than the other graduate fund. Give my, I can't remember its precise name. And that is a form of a dividend to potentially that could be considered. I don't necessarily see it as a potential dividend because it's not obligated to any particular end user. They just give it as a gift. But the source of those funds come from the profit or the efforts of New River Power. I accept that.
So I mean,
But I don't necessarily call it a dividend, though I see the similarities.
I think we're in full agreement that they're definitely not dividends. And so given that New River does not issue dividends, when we're thinking generally about DCF analysis, when there is a reduction in dividend growth or a suspension in dividend payments from the perspective of an equity investor, that's a risk that that equity investor might bear or experience. Is that fair?
Without a doubt. And the price will undoubtedly over time reflect that decreased expectations.
And that would be for a utility that has that sort of, equity investor or that risk. That's a risk that would ultimately impair that utility's ability to attract capital.
Right, and possibly raise. In fact, the simple way of how it often works is companies will issue new equity at certain times every 5 years, or it's not done every week or anything, or every year. But periodically they'll issue new equity. If the stock price is high, they get a lot more money. And then, of course, we all know about things like dividend employee stock ownership plans and other ways that the utility is better off with a high stock price because it does provide capital to the entity. Again, employee stock ownership plans, other dividend investment plans, and of course, the issuance of new common equity.
Gotcha. Okay. So I think because New River does not have equity investors, and even if it did have investors, that's not a risk that they bear. Given that that is maybe not a comparable thing that can be compared between the two utilities, your DCF analysis still relies on dividend growth rates and utilities with dividend-related risks, even though we both are in agreement that New River does not issue dividends.
Correct. But I was asked to testify on the required rate of return for this company. So my starting point is what will be the required rate of return for what I can see be perceived as a conservative risk utility. And that's why I picked the four screening elements that I have. From that was a bit of market insight that I use as evidence to base my opinions on and my recommendations to this commission.
Yep. So in calculating the dividend yield and expected growth rate component of your DCF analysis, you relied exclusively on value line data.
No, I also looked, the earnings per share numbers come from Yahoo, which is, they aggregate earnings consensus forecast from other folks. And there's a column in the DCF analysis called earnings or forecast earnings.
Okay.
So yes, there are two main sources. Value would be the predominant one, but also look outside for other earnings, consensus earnings reports.
Okay. So, taking into account that you also did a Yahoo analysis for purposes of calculating or I guess proposing your return on equity, fundamentally sort of the only checks that would have been on the value line data would be the Yahoo data and the regression analysis that you conducted.
And those are my two methods I employ. You were correct.
Okay.
I mean, obviously, I'm aware of what's going on in the financial markets as I try to allude to in my testimony. But that's the primary check. And then, of course, there's also the exhibits you spoke of where our Regulatory Research Associates or S&P Global publishes their required returns on equity that have been approved by other commissions over the years. And I looked at that, and as you see, the last 12 months, ending March 31st, or March, the end of March this year, was 9.13, I believe. And so that's on the exhibit there. And that even includes the 9.8 award for 2023, which was one single case. And in my mind, I had to discount that because the other years, there's multiple cases that represent an annual time period.
Okay. All right. Just going to have a couple more questions here. So let's talk about the regression analysis that you conducted. So on page 25 of your direct testimony, beginning at line 3, You sort of described that regression analysis. And as I understand it, it's sort of trying to determine or analyze the relationship between allowed returns and A-rated utilities. Is that right?
Correct.
Okay. So this regression analysis you note, and this is starting on line 10, it's that same page. It attempts to quantify the risk premium that equity investors require to invest in a utility stock instead of bonds.
Yes.
Okay. Further down, line 15, same page, you note that, and I'm quoting you here, the use of utility bond yields is preferred over the use of United States Treasury yields because it allows the examination of the added risk premium associated with an investment in electric utility common stocks.
Yes, I'm just making a little informational sentence. Other people employ the risk premium model, and commonly people use treasury bonds as their bond measure. And I think it's, like I said, it removes an error, possible error when you limit the default to public utility bonds. And plus my adjustment I issued back in '93 and ever since then, the model does attempt to look at what is the additional return required to go from a bond to a stock. And so staying with the same entity, type of entities, which is what the public utilities index is comprised of, is 6 or 8 different utility bonds that are being traded in the secondary market. And that's how they construct that index.
So just to be really clear on this analysis is sort of trying to determine what additional risk equity investors bear by investing in a stock as opposed to a bond.
Correct.
Okay.
Utility stock or utility bond.
However, to the extent New River even has investors, they wouldn't have that option between investing in New River stock or bonds.
That's correct.
The only option would be to invest in debt.
I mean, the investor in New River is, of course, Appalachian State University, i.e. the state of North Carolina.
Okay. All right. Last couple questions. You propose a 50-50 hypothetical capital structure.
Yes.
All right. You note on page 16 of your direct testimony, and let me try and find the specific line number so you can read along with me. Just give me 1 second. I'll just read this out to you, and obviously you can agree to it or not. So you write, the use of a hypothetical capital structure is appropriate because of the absence of publicly traded companies with similar capital structures. And this is actually, believe, lines 3 through, well, it's lines 3 through 7, really. So I'm sort of paraphrasing, but is that a fair representation of your testimony?
Yeah, and allow me to take a moment here. There was a similar case before I testified for the Commission's North State Water. They had a capital structure of roughly 70 or close to 80% debt. Now, I have amazing respect for Bill Grantmeyer. I know we all do. But he taught me, persuasively, tried to talk me into using the actual capital structure in my testimony because he's a consumer advocate. And so am I. But I have to testify before you folks. He sits over there. The point of the matter is that was extreme capitalization. That was in the public's favor, but it was unreasonable. I could not determine a cost rate for equity for an investor who would buy a stock that has that much debt leverage because there's so much risk there. The converse is true of this case. It's hard to find an equity investor in utilities who will say, I'll invest in a company that has only 35% debt, because most utilities out there are in the ballpark around 50% to 55% to 60%, maybe as low as 45%. But those are the ranges of capitalization ratios that you see in the marketplace. So I can't testify to the commission what's the appropriate cost of equity when I'm dealing with a capital structure that's part of my language whacked.
You've had a chance to review New River witnesses Randall Haley's direct testimony.
Yes.
And you've obviously been with the public staff for a very long time. So you're aware that the commission has approved New River's actual capital structure in the past.
I don't recall that. I think I worked on the last rate case since 2017, and I think we used hypothetical capital structure there too.
Subject to check, would you agree the commission approved a 93.58% equity to 6.42% long-term debt capital structure in the E-34 sub 32 proceeding?
Which year was that case, may I ask?
97.
97?
I believe.
Okay, I was thinking about 2017. I testified in 2017. Possibly that was, but I did not work on that case, to be honest with you. I did not.
That's fine. No further questions.
As tempted as I am, I will not ask any questions in the interest of time.
Okay, Mr. Sayers, I don't think that you reserved any cross time.
Other than noting at the bottom that we were reserving in the event it needed to be clarified for the support of stipulation, I don't think it needs to.
Okay, so no cross-examination from New River.
Correct.
Okay. Redirect from the public staff.
One moment, Commissioner. Thank you. We don't have any questions.
Okay, Mr. Hinton, I just have one question that actually comes from commission staff, and this is in regard to the usage adjustment that you discuss in the settlement. And this is on page 5. You may not even need to turn to it, but you, as part of the stipulation, New River and the public staff agreed to eliminate the usage adjustment that you had proposed in your direct testimony. And can you explain whether New River and the public staff agreed to the public staff's customer growth adjustment that you had proposed in your Exhibit 12? And whether the customer growth adjustment was revised in the stipulation as well?
My understanding is that the customer growth adjustment remained intact. And I can't say that I have no knowledge of it being adjusted in the stipulation either. So I would testify to my knowledge, it remained intact. And as you said, the usage adjustment was withdrawn. And I think my reason I noted for the adjustment was seemingly excessive and on reflection, and it was it was something that I think was reasonable to negotiate away.
Okay. And do you know what the final calculation for customer growth is then?
It'll have to be a late file exhibit. I don't know. I mean, no, I don't.
I can ask the company that question. Okay. Chair Mitchell?
All right, Mr. Hinton, very quickly, you heard my questions to Mr. McLaughlin. Do you have anything to add in response to his responses to my questions regarding exposure of New River customers to fuel price volatility?
Yeah, hedging. I'm afraid the best I can say, I'm no more smarter than James McCall.
All right. Okay. Cost of gas has been revised to $5, I think, in base rates, $5 and change. To my recollection, public staff didn't take issue with that in testimony or in the settlement. And so can you just react to the $5 in base rates? I mean, are you comfortable with that?
That's certainly not my testimony, so please accept whatever I say as just an outsider looking in. But, I know the cost of gas is down. I mean, the spot price of gas is around $3, if I recall correctly. And so now, over the time period that they'll be purchasing, I can't say. But if James McLaughlan has not an issue with that, then I support his testimony.
Okay. I didn't ask James about that specific question, but I'm not hearing you take issue with it at this point.
No, I
Okay.
wouldn't. I mean, because of the PGA, the gas cost adjustment process, even though I've been here forever, it seems like I'm a little rusty on how the mechanism fully works every time. I don't know if there's how much of a lag effect is in there, and I haven't reviewed the contract with Carolina Partners.
All right, and can you refresh my recollection? I know we had a PPA adjustment recently. What is the cadence? What's the typical cadence of those PPA? Is it annually?
To be honest, I cannot testify.
Okay, all right, thanks, Mr. Hinton.
It's not me.
Now we'll move to questions on commission's questions. I apologize, Commissioner Clodfelter has a question.
Ms. Hinton, I listened to your testimony. I'm just curious about something. This commission's authority to set the rates for this entity, it's supposed to set a rate only for the sale of surplus power that the entity has beyond the needs of the institution that owns it. That's a little bit different from being in the general business of selling power to the public, and that's why it's not a public utility. Our authority comes from a statute other than Chapter 62. Is it the public staff's position that we have to follow exactly the same rate-making methodology for this entity that we use for entities that are subject to the jurisdiction of Chapter 62? Is that the public staff's position?
Waiting for my attorney is to chair pen.
Excuse me, sir? I just didn't hear you.
I'm waiting for my attorneys to chair pen.
Well, let's leave it as a rhetorical question then, and maybe they'll want to address it in their briefs.
My common sense response is that you should regulate them like you regulate any other utility because the customers expect that.
The General Assembly could have told us to do it that way, couldn't they?
They could have, but
And they didn't, did they?
when was this legislation written out now? And that was when maybe Boone was a small mountain town. Now Boone is a large metropolitan area. Well,
That may be, let's just leave the question at that.
I'm
Maybe-
sorry, Dr.
Maybe your
Commissioner.
counsel will address it in their briefing.
Yeah, maybe so.
Okay, now we'll go to questions on commission questions, starting with Ms. LaPlaca.
None, thank you.
Okay, Appalachian Voices.
None from Appalachian Voices.
Okay, New River.
30 seconds. In response to Commissioner Clodfelter's questions, were you involved in the rate cases for Western Carolina University in 2016 and 2020?
Yes, I was.
And the New River rate case, last New River Light and Power rate case in 2018?
17.
17. And in each of those cases, was there an assumed capital structure of 50/50?
Correct.
And was there then a assumed return on equity and cost of debt in those three cases?
I can't say it when you say assumed. It was.
I mean, a rate of return on equity, and a cost of debt.
Correct.
Yeah,
There
thank
was rate of return on equity and debt, and the rate of return on equity was determined in a similar method that I've done today. But I cannot remember precisely how much the change there was from what I pre-filed versus what was actually approved or submitted for approval.
So the rate making that the commission undertook in those three cases are consistent with the public staff's testimony and the stipulation of this case.
Yes.
But the overall rate of return in this case would actually be, it would be the lowest of those other rate cases I've just discussed, as it's not the overall rate of return.
Yes, and I would say it's largely due to the cost of debt coming down.
No further questions.
Thank you, Commissioner. I don't know that I have a question, but if the commission would, the customer growth adjustment and customer use adjustments are found at Hinton Exhibit 12, which is the final page of his testimony. If that sort of responds to one of the commissioner's questions.
Thank you. Seeing no further questions on commission questions, does the public staff have a motion that you would like to make?
Thank you. Presiding Commissioner, the public staff would respectfully move that Mr. Hinton's 12 direct testimony exhibits and single settlement testimony exhibit and 2 appendices found in his direct testimony be entered into the record and bear the same identification as they were when pre-filed.
Okay. Seeing no objection, your motion is allowed.
Thank you.
Mr. Hinton, thank you for your testimony, and you may be excused. So this takes us, I think, to the end of the interveners' witnesses and testimony. So it is now witnesses from New River.
New River Light and Power calls Ed Miller to the stand.
Good afternoon, Mr. Miller.
Good afternoon.
Will you place your left hand on the Bible and raise your right hand? And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God. Thank you.
Would you state your name and business position and address for the record, please?
My name is Edmund Chris Miller. I am the general manager for New River Light and Power located at 146 Faculty Street Extension, Boone, North Carolina.
And did you cause to be filed 7 pages of direct testimony with 2 exhibits at the time the application was filed in this case on December 22nd, 2022?
I did.
Okay. And did you cause to be filed 17 pages of rebuttal testimony with 2 exhibits on June 23rd of 2023?
I did.
And did you also have filed a 1-page summary of your direct testimony on July 7th and a 1-page summary of your rebuttal testimony on July 7th?
I did.
We would ask that the pre-filed testimonies be incorporated into the record as if orally read from the stand, and that the exhibits be identified as marked.
And Mr. Drews, for clarification, my notes show that Mr. Miller's rebuttal testimony consists of 19 pages. So let's just make sure that we have the correct number of pages.
I'm going to need a check on that, whether it includes.
I have 19 pages and 2 exhibits.
You got it.
Yeah. If you give me just a second. My printout copy here has 17 pages.
Yeah,
Okay.
that's 2.
So the Mr. Miller's direct testimony filed on December 22nd of 2022, consisting of 7 pages, and his rebuttal testimony filed on June the 23rd of 2023, consisting of 17 pages, will be copied into the record as if given orally from the stand. The 2 exhibits attached to the direct testimony and the 2 exhibits attached to the rebuttal testimony will be marked for identification purposes as pre-filed.
Mr. Miller is available for cross-examination.
So we have cross-examination from Appalachian Voices and Ms. LaPlaca. So Appalachian Voices, would you like to begin?
Sure thing. Nick Jimenez for Appalachian Voices. Good afternoon. Mr. Miller, you testified in your direct testimony on page 7 that NRLP is proposing a new net billing, correct?
Yes.
Has NRLP ever offered net metering in the past?
Can you define net metering?
How about net billing?
Net billing, no.
Are you familiar with the 1.4 kilowatt photovoltaic system located on Catherine Harper Hall, Kerr Scott Hall at 397 River Street in Boone, North Carolina?
I'm not familiar with that specific system on ASU. Catherine Harper Hall.
That's right.
And the size?
1.4 kilowatts.
I apologize. I'm aware of a number of solar sites on Appalachian campus. I can't specifically recall that specific site.
Are those solar sites compensated through net billing or net metering?
No, they are not.
How about the windmill? Do you recall your responses to Appalachian Voices Discovery requests concerning buy all, sell all, and the difference in compensation for the windmill?
The windmill is on Appalachian campus. It's on the campus rate, which addresses the benefits of solar and wind customer generation in that tariff. So it does not fall under either one of the customer generation rates, one that's being proposed in the existing one. It's
Okay.
under the ASU's tariff.
And as you explained it, do you recall your explanation in Discovery? I'm trying to avoid introducing exhibits to take more time. See if we can just go from your recollection. Do you recall that you said that it is compensated for the electricity generated at the per kilowatt energy charge for the ASU campus?
It is addressed through the two demand components under the Appalachian State tariff. And so there's two demand components and an energy component for that tariff. One is the actual red demand. The other one is compensating, taking the demand for the generation and adding it back. So it compensates for the fixed cost recovery approved by Utilities Commission, recommended by staff.
Excuse me, Mr. Miller, could you pull that microphone closer to you? So especially if you're turning to
right.
address.
I apologize. I'll do my best. Right. The Appalachian State campus is served under one master meter. That master meter is under the approved tariff that serves the campus. It's the ASU billing rate. That billing rate is designed to net out any generation that's behind the campus meter. That tariff also includes a demand rate that is actual demand that we read at the meter. It also takes into account a charge where we take that demand rate and we add the demand that is recorded on all the generating facilities on campus in an effort to recover all fixed costs.
Okay. I do have a couple exhibits for this next question. Apologies. Part 1A. Sheet. Take. Let's call this. This involves 4 exhibits. The first I would like to, I've marked for identification as Appalachian Voices, cross-examination, Miller, direct exhibit 1. This is NRLP response to 5th set of written discovery requests to New River Light and Power of Appalachian Voices. This is item 5.1. And I'll just hopefully pass this out. Thank you.
Yeah.
I'd like to proceed and then perhaps just do them all, ask Mr. Miller about them all at once, if that's all right. We can.
Yes, I think it would be, go ahead and pass out all of the exhibits and we can have all of them pre-marked.
Thank you. Thank you, sir.
Thanks.
So if everyone has the exhibits, this is to make sure we're all on the same page. As Appalachian Voices, cross-examination, Miller, exhibit number 1, I have New River response to 5th set of written discovery requests.
Correct.
And then for Appalachian Voices cross-examination, Miller, exhibit number 2 is the entitled New River's response to Appalachian Voices data request number 5 that begins with proposed ASU solar facility.
Correct. Item 5-1A.
5-18, okay. And then exhibit number 3 is New River's response to Appalachian Voices data request number 5, item 5-1A.
Correct. The Excel.
Okay, and then exhibit number 4 is data request number 5, item 5-1B.
Correct.
Okay,
Thank you,
great.
Commissioner.
You may proceed.
Mr. Miller, do you recognize these exhibits?
I'm certainly seeing the name on them, so I must say that I've been part of this investigation and this pursuit. Yes.
Okay, thank you. And I want to recognize that the in Exhibit 1 identifies Randall Halley as responsible for that response, but you were included in a lot of the other exhibits, so I wanted to ask you about this anyway. I just wanted to acknowledge that. Okay, so according to Exhibit 1, this is all about a proposed ASU solar facility. Is that right? You see the end of the end of the discovery request there?
We certainly were looking at any opportunity we can to provide service to our customers, including Appalachian. So we were investigating possible solar site. That's correct.
Okay. And the email chain in Exhibit 4 is your back and forth with Witness Halley concerning how to compensate the potential ASU solar facility?
Haven't read it thoroughly, but it certainly appears to be that way.
Okay. And the Exhibit 3, the Excel spreadsheet, that's something that Witness Halley prepared at your request?
I can't say that he addressed it or that he prepared it or not. I don't know. I don't know who prepared that spreadsheet.
Okay. That's good. I want to focus on Exhibit 2. Do you see at the bottom where it says thoughts? Ed, did I capture your initial thoughts correctly? That's you, right?
That's correct.
Did that capture your thoughts correctly?
To the extent that we are trying to find ways to bring solar and facilities and projects to New River that serves all of our customers, I would think that the intent of this letter is to try to look at opportunities that better our system and provide service to our customers.
Let me see if I understand how compensation would work under this plan. So tell me if this is incorrect. NRLP would calculate what its monthly CPP bill would have been without the solar facility. It's kind of step one. Does that sound right? If it helps, you can, it's in the second paragraph, the third sentence.
Can you repeat your question, please?
I'm calling it the first step, but one part of this analysis anyway, is that NRLP would calculate what its monthly CPP bill would have been without ASU's solar facility.
That is correct. I see it also wanted to, the next step is to ensure savings to the customer and ensuring that no customers that are not participating are not negatively impacted. That's correct.
Okay. So then the difference, those savings would be passed to ASU in cash. Is that right?
Chair Kimright, I have a objection here. It's not apparent to me what the relevance of this proposed facility is to the rate case, since the rate case is dealing with actual costs that have been incurred by New River and not anticipating to recover potential cost of a future potential proposed solar facility.
And would you like to respond?
Certainly. This illustrates how ASU thinks about compensating, rather how NRLP thinks about compensating solar that ASU installs compared to solar that the rest of its customers install.
Okay. I'm going to overrule the objection. With that being said, let's focus as much as we can on the issues that are very directly related to the to this particular matter. But please proceed with this question, and I will ask the witness to answer the question.
Thank you. Okay. And so the difference, the savings that we just talked about would be passed to ASU in cash. Correct?
I don't know if it'd be cash. I don't know if it'd be a credit to a bill. This was an initial investigation on seeing how we could possibly place solar on New River's system. It happens to be on ASU. Quite frankly, looking at this document, I don't even know if it's on ASU's campus. Okay. It's for ASU. I believe this was a possible exercise, and we did a number of work with the Energy Center, looking at DOE grants, looking at opportunities to bring savings to New River. This particular project, again, we go through the litmus test to see if it benefits the customer and all customers at New River. So there are a number of projects that we continue to work with the faculty and other folks that come to New River to see if there's a potential project.
Okay. I'll skip to what I took away from this as the problem that you identified. NRLP would charge ASU the same amount in an extra facilities charge, right? At the end of that first paragraph, as part of the proposal.
Part of our tariffs, we have an extra facilities charge. If any customer has a request of service that's above and beyond normal services, then we have an extra facilities charge. And we are exploring to see if that could apply.
Okay. And extra facilities charges are based on 0.87% of the cost to connect a facility, right?
I don't have the tariff in front of me, but there's defined in the tariff of how we calculate our extra facilities charge based on the capital investment.
It's in the third paragraph, third sentence, 0.87%.
Okay, and at this time, I don't even know what our existing tariff or what our extra facilities charge is. So it reads 8.75. Excuse me, 0.887%.
And then the monthly savings, again, in this third paragraph, if you assume the facility is 1 megawatt solar only, the estimated monthly savings were $6,333.
This is what the document says.
And dividing that by the 0.87% extra facilities charge implies a cost to connect of $724,000.
That's what the document indicates. Again, this was one of many projects that we looked at to explore, looking at a number of solar sites as our customers have asked us to do, to look for solar to come to New River. And so this is one exercise where we tried to find ways to bring generation to the high country.
And if you look at Exhibit 3, the last line, that amount is too high, right?
I apologize on my numbering here. Exhibit 3, is that the email correspondence?
No, sir, that's it's sort of an Excel spreadsheet. It looks like this.
Okay. NRLP, the cost to connect facility is $723,000, and it indicates this is too high. Okay.
And that was the reason the proposal was amended?
Again, I do not recall the specific proposal. I do not know what reasons we came through. We look at a number of opportunities of installing solar at other projects at New River. We continue to work with the university that either we bring ideas to the university and the faculty, or they bring it to us and we investigate and look and see if the feasibility, see if it betters the utility or our customers.
So considering those examples, isn't it true that ASU has offered net metering or net billing to, rather NRLP has offered it to ASU, but not to its other customers?
There was no offer. I mean, this is a study. This is us putting out a piece of paper and seeing if we can make something work. I don't believe that there was any proposal or any creation. Certainly nothing was brought in the form of net metering or net billing to gain approval for that. And we would have to go through that next step if we felt we had a project to see what requirements there were to implement that.
Moving to your rebuttal testimony, you discussed the prepaid program in response to witness Hoyle's testimony concerning energy efficiency and demand side management programs. This is on page 8 at lines 5 to 24.
This is my rebuttal?
Yes.
Okay. And the line you're referring to?
5 to 24, actually. You discussed witness Hoyle's testimony concerning EEDSM and then moved to NRL on line 23. NRLP was working to develop a prepaid service rider.
That's correct. We are currently working with public staff and gaining approval from the commission. We have a prepaid program at New River Light and Power that we offer to our customers.
I'm going to try to skip an exhibit and go from your recollection. Do you recall in response to a data request saying that this program has also shown indication of reducing energy consumption since customers are more aware of usage?
I do recall that. I recall that based on a number of studies that was shared with us, the prepaid program, when you provide that to the customer, they're more sensitive to their usage and it reduces their consumption.
Also going from your recollection, this is the prepaid service rider filed June 22nd, 2022. Do you recall, or is it your understanding that a customer, when their balance hits zero, they're disconnected the next business day?
We have a policy set with the prepaid program where when the customer is notified when they're getting close to having a zero balance, and once they reach that zero balance, then they're terminated or disconnected for non-pay. If then there's some restrictions regarding weather and how close they are to the end of the business day. But we would make every effort to communicate with the customer prior to disconnection.
And again, recollection, this is your from NRLP's latest report on the prepaid service program. Does it sound right that there were between 47 and 120 disconnections per month, except for February and March in 2022?
I cannot tell you the number of disconnects that we have at New River.
You could, if subject to check, would be fine too, if that's.
We'll have to check, but I have no idea what the disconnects are at New River.
Same for 69 customers who were with more than one disconnection within a 90-day period.
We're subject to check. I can't verify that.
Are you aware that there is a commission rule against disconnecting service for non-payment of bills without having first tried to induce the customer to pay, and that NRLP sought and obtained a waiver of that rule to establish the program?
The purpose of the prepaid program was that we would notify the customer electronically before disconnect, but there is no paper. It requires the customer to have an email for us to implement the prepaid program, and public staff was very careful that we adhered to communicate with the customer.
All right, can you tell me how long it is between when a customer on Schedule R runs out of money or hasn't paid their bill and when they're disconnected?
Are you referring to prepay or are you referring to a regular customer?
On Schedule R, regular resident.
Regular R. Customer, I believe, goes nearly 2 months before we actually disconnect them. It is I cannot tell you the period of time that they are between delinquency and actual cutoff. No.
So the indication of saving, reducing energy consumption since customers are more aware of their usage, is it fair to say that that's because the customers know their power will be cut off the next business day if they run out of funds?
I think it's, you're referring to prepay now?
On prepay, sorry, yes.
Going back to prepay. Okay. Purpose of prepay is to continue to communicate with the customer their usage. We can notify them and they can and they're notified where their usage is and where their balance is. So it is not intended to enhance or improve collection at all. It is not targeting any particular class or demographic. It is only the intention of the prepaid program is to offer a service so customers can be aware of their consumption.
Does NRLP consider the prepaid program a form of energy efficiency or demand side management?
New River Light and Power with our AMI system gained approval from public staff or recommendation from public staff that we could implement the prepaid program as an effort that satisfies the requirements mentioned in previous testimony regarding energy efficiency.
Okay, so is that a yes? NRLP considers it an energy efficiency program?
And public staff also agrees that that's what we could use to address the pursuit of energy efficiency at that time. Well, obviously, we were pursuing other energy efficiency efforts at New River regarding grants and funding, but that right there specifically, since our last rate case, we certainly implemented the prepaid program since we had our AMI system, and we were eager to offer that to our customers.
In response to witness Hoyle's testimony concerning EE and DSM programs, you also mentioned that NRLP offers its Green Power program.
That is correct. We offer our Green Power program, and that was only the result in the last, since our converting to our new wholesale provider, where we allowed to pursue the Green Power program, which serves all customers, offered to all customers.
I'm going to try to skip more exhibits and just test your understanding as you sit here today. The power purchased through the Green Power program comes from a number of hydroelectric dams. Is that right?
We entered an agreement with a utility, Brookfield, and we purchased 17 million kilowatt hours of hydro generation to meet the request of our customers under the Green Power program.
To the best of your knowledge, were any of those hydro facilities constructed as a result of the Green Power program?
To the best, no.
And to the best of your knowledge, would they shutter without the Green Power program?
Can you repeat that again?
To the best of your knowledge, would they shutter or stop operating without the Green Power program?
I have no idea whether they would, if it was dependent on the Green Power program or not. I reached a wholesale agreement with Brookfield. They met that requirement and served us electricity.
So you testified that an NRLP survey indicated that 2/3 of customers would be willing to purchase renewable energy at a premium if offered, but fewer than 200 customers or fewer than 3% signed up. That's on page 16, lines 10 to 14. Is that right?
That's a correct statement. As of last month, we have 175 residential customers that signed for the Green Power program. And our surveys indicated that over 4,000 residential customers should be signing up. Our survey was conducted in 2017 and 2020. The 2020 was very specific to the boundaries of the Green Power program. So the response to the Green Power program, although we continue to pursue, is somewhat lower by a factor of many of what was indicated by our customers when they completed the survey.
And you testified that NRLP continues to find that that indication of desire for program does not necessarily mean that customers will subscribe when it's offered, especially if there's an additional cost. That's again on page 16, lines 15 to 16.
We found that when we asked in our survey, in the 2020 survey, we asked specifically if a customer would pay $5 or 250 kilowatt hours, or approximately 1/3 of the average residential customer's load. We had an overwhelming response from residential customers at that time that they would subscribe to the Green Power program. We were also specific that it was not just specific to one source, but it was also, it could be hydro, wind. We were not specific to solar or hydro or anything else. And the response to the customers was caused us to spend the effort and the expense to pursue the Green Power program. And at this time, we have 175 residential customers. However, we've offset 17 million kilowatt hours of purchases from CPP by the subscription of Appalachian State, Town of Boone, and the county, Watauga County, who has subscribed to the Green Power program and sees it as a success. But as from a residential standpoint, we do not have a significant subscription.
Besides the additional cost, has NRLP considered other reasons customers might not sign up for Green Power?
I cannot understand based on the survey, the customers that said yes to the survey, we are offering through the Green Power program. So I am not real clear why our customers are not subscribing.
Does NRLP consider the Green Power program either energy efficiency or demand side management?
Repeat the question.
Does NRLP consider the Green Power program energy efficiency or demand side management?
We see it as a customer service or an option to our customers that they requested, again, mentioned through our surveys, and we've pursued that based on their response. As far as energy efficiency or demand side management, we've pursued other areas that probably typically align more in energy efficiency or demand side management than the Green Power program. The intent of the Green Power program, as signing our CPP contract, is to offer choice to our customers of where their energy comes from.
Almost done. You testified NRLP has not proposed a slate of EEDSM programs because it does not have the staffing and resources, and because it does not qualify for cost recovery under the EEDSM statutes. And for that, you cited NRLP's legal counsel's opinion. This is page 9, lines 5 to 9. Does that sound right?
That is correct.
NRLP has not sought the Commission's determination whether it can recover for EEDSM programs either under the EEDSM statutes or otherwise, has it?
We have not.
NRLP developed Rider RER for the Green Power program voluntarily, right?
That is correct.
In response to consumer interest.
That is correct.
No further questions. Oh, sorry. I'm going to pass to my counsel. Co-counsel.
Good afternoon, Ms. Miller. Menashe Magruder, co-counsel for Appalachian Voices. Just, I think probably a couple questions, very brief. Mr. Miller, in your direct testimony, this is page 3, beginning on line 10, you note that New River's rates compare favorably to other North Carolina electric utilities. Is that right?
That is correct.
Okay. And in your testimony, this is the same page, I think you state that based on 2021 EIA data, New River was the lowest cost provider for residential consumers in North Carolina.
That is correct.
However, that rating would only apply to the rates that were in effect when EIA conducted that analysis.
They were reported by EIA 2021 and New River consistently is one of the lowest cost utility providers. But I can only go on the EIA data. I can't speculate. I do have current numbers as how we compare. Obviously, we remain among the lowest cost providers, and certainly we will remain lower. We continue to remain, even after the proposed increase, will remain lower below our surrounding utility. And after the phase-in of both Duke Carolinas and initially on Duke Progress, we will remain among the lowest cost or the lowest cost for those utilities.
So you kind of, I think, predicted my next line of questioning. Obviously, New River is proposing to increase its rates. Have you had the chance to review Bob Hinton's direct testimony filed June 6th?
Specifically?
Specifically with respect to what the, again, understanding that there's a stipulation that will sort of change things based on the proposed rates. Did you see sort of his analysis as to what the average bill would be if those rates were approved?
I do not recall specifically what his bills were.
Yeah.
I've worked with our consultant, Randy Howley, who's generated those typical bills based on 1,000 kilowatt hours for a residential customer.
Sure. Commissioner Cameron, may I approach? I have, it's just the page where Mr. Hinton sort of lays out what the average bill would be. And I have additional copies, but this is just from the record. I'll give a copy to Mr. Miller and then also to council just so they can see it.
Thank you.
Okay, can I have you read out loud into the record lines 10 through 16 that are on that page?
In addition, the proposed increase in residential rates would result in a $139 average bill, assuming 1,000 kilowatt hour usage. This is similar to the 133 average energy bill that the same customer would receive from Blue Ridge Electric Membership Corporation, or the $138 bill they would receive from Duke Energy Progress. NRLP customer bills would be higher than North Carolina customers served by Duke Energy Carolinas and Dominion Energy.
Okay, thank you. And are you aware of any testimony that New River or the public staff has filed since the filing of the stipulation that recalculates what that average bill would be?
Can you repeat that question?
Are you aware of any testimony that New River or the public staff has filed since the filing of the stipulation that would recalculate what the average bill would be?
I'm not aware of that, no.
No further questions.
Ms. LaPlaca?
Yes, thank you. And I'm going to ask leading questions so that we could just get to the point here. Mr. Miller, I just want to ask you a couple questions about basics of New River Light and Power. Tell me if you agree or disagree. There are about 9,000 meters in New River District. About 22% of the retail revenues are from ASU, and about 78% are residences and businesses. Is this correct?
Subject to check.
Okay. Over the last 15 years of buy all, sell all, we've had 15 solar systems installed. So that's about one per year. So that if New River wanted to have 5% of its meters have rooftop solar, that would be 450 meters out of 9,000 meters. It would take 450 years at the current rate to get to a 5% penetration of rooftop solar. Is that correct? Do my numbers sound right?
I cannot do numbers that fast. I know that New River's buy all, sell all has to, in working with public staff, we are to try to make sure that our rates are non-discriminatory and do not cross-subsidize, as we've heard for the last 2 days. So the rates that we're offering at New River and what we've proposed continues in that spirit of keeping, ensuring that there's no cross-subsidization. Obviously, with this rate adjustment, we're seeing an increase in both the buy all, sell all and the proposed net billing rate, to where the compensation to the generating customer is increased.
Okay, so considering that only 15 meters out of 9,000 have solar, that is, by my calculation, 0.004% of the current customers for New River Light and Power have some kind of rooftop solar. Is that correct?
Again, I'm not able to do the math. I know that we're consistent with other public utilities in North Carolina that offer similar rates as New River. So I can't speak to the math that you're citing, Ms. LaPlaca.
Okay, moving on to what Boone wants. Are you aware, Mr. Miller, that I served on the Boone Town Council for 2 years?
I am aware of that. And
Yes. And when I was on town council, I got to know a lot of people. I talked to a lot of folks. And are you aware that in this docket, the town of Boone, that's the town council, filed a letter in support of fair net metering, and that they recognize that Boone has very little rooftop solar, and that the Boone Town Council would like fair net metering, which means no more than $2 per kilowatt per month standby charge. Did you see that letter, sir?
could you provide that letter, please?
It's in the docket. It's been filed in the docket.
Can I have a copy of that letter, please?
Yeah, I'll be happy to send it to you if you want to wait right now. Actually, sir, I'm trying to save time. It's filed in the docket. I know that you got a notice because we all get notices. I have 10 minutes, sir. I want to ask relevant questions, not waste time on making points that we all know are true.
If you are aware of what she is asking about, please respond. If you're not aware, please respond that way.
I am aware that the town of Boone approved a letter on June 28th to be sent to the Utilities Commission. I'm not aware if that letter was received by the county. That's what I'm asking. Can I have a copy of that letter?
I'd be happy to send it to you. It's in the docket, sir. I checked. It's in the docket. Similarly, other letters were filed, one by the Blue Ridge Women in Agriculture, which represents 100 local food producers and 200 to 300 customers per week who also want rooftop solar. Are you aware of that, sir?
I'm aware of that letter.
Okay, thank you.
The town of Boone letter, is it in the docket along with the previous letter that you mentioned?
Yes, they both are. I checked.
Can I ask if that's in there?
So
Last time I checked, I have not seen the town of Boone's letter.
Mr. Miller, I think that the questions that you're being asked is just if you are aware of whether it's in the docket, and I think that you can answer the question
I'm
whether
not
you
of
are
the
aware
town
or
of
not
Boone.
aware.
I'm not aware of the town of Boone in the docket. No.
Okay.
I'm not
And
aware of that.
for the sake of the court reporter, please don't talk over another
I
person.
apologize.
Okay, moving on to another line of questioning. Mr. Miller, has any other customer ever intervened in a docket besides me? Are you aware of any?
I'm not aware of any intervention towards in a rate case with New River Light and Power.
By any customer ever?
I am not aware of an intervention when we file a rate case of any kind. I'm not aware of
Okay.
any intervention.
As a customer and one who's been trying to put solar on my home with my partner for 5 years, I'd like to go through some numbers, please, and ask you if they're accurate. Under buy all, sell all, my partner and I, who refinanced our home 4 years ago and put away $30,000, we've been trying for years to put solar on our house. And the reason that we couldn't under the current rules is because if we put that solar up on our roof, we could not use any of that electricity. Is that true under the current system? Under buy all, sell all, we could not use any electricity, so-called behind the meter.
Buy all solar is two separate meters. So we read what's generated and what is consumed by the customer, and there is no net effect.
So please, sir, just answer yes or no. Under buy all, sell all, the customer who puts solar on their roof cannot use any of the electricity that is generated by that system. Is that true?
That is true.
Okay, thank you, sir. Now, under the new system, net metering, thank heaven, and I appreciate New River finally offering that. I want to explain what would happen to us as customers, and I want you to tell me if I'm right or wrong. We plan to buy 10 kilowatts of solar. And just using round numbers, it would cost us $6 per kilowatt per month. So therefore, we would be paying $60 a month fee, which translates to $720 a year. Over a 30-year life of that system, that means that we would pay about $22,000 more for the system than the $30,000 initial cost. Does that sound correct, ballpark?
The net.
Yes or no, please, sir?
I would like to clarify. I would like to answer the question that's given.
Okay.
Please go ahead and answer the question as best as you're able.
Best that I'm able. Yes, with the net billing rate, with the full retail rates being offered to the customers, there is a fee to the customer for based on 10 kW at $6, it'd be $60 a month. That is correct. Obviously, we are seeing full retail rates being credited to the customer as well. Yes.
And Mr. Miller, are you aware that a previous utility that imposed a monthly solar fee of $50 a month, which isn't really as high as New River's, experienced a 95% reduction in rooftop solar applications after they instituted that fee? It was in my testimony.
I have not confirmed what you're saying, but I've read your testimony that was what you shared in your testimony. Yes.
Yep. And Mr. Miller, is New River Light and Power committed to giving customers what they want?
We want to make sure that all customers are treated the best, provide the highest level of service we possibly can. That's why we generated the Green Power Program. That's why we offer prepay. That's why we respond to the customer surveys, why we continue to provide the level of service we do.
And Mr. Miller, as a customer who's watched the Green Power Program really not get off the ground, I can tell you why we didn't do it, because we don't want hydro that comes in on the transmission line. We want local clean energy. Does that sound like it could be a reason for the other customers in Boone who up to 90% have indicated an interest in clean energy, and yet very, very few people signed up for the Green Power Program?
I have not heard I have not heard a major communication from our customers that they are declining the Green Power Program because it is not local or is not solar. I'm not hearing that information at all.
Mr. Miller, I remember getting a number of requests from New River during some heat waves in Boone. And it said, hey, everybody, reduce your energy use. And I remember writing back and saying, well, if we had rooftop solar, we could reduce our energy use. Do you recall that?
We have a Beat the Peak program where our wholesale price cost, whether it's the current wholesale rate or the previous wholesale rate, we are trying to incentivize our customers to curtail their load so that the savings that we'd see through our PPCA every year would be passed on to our customers. It was an effort to help customers save money on their utility bill.
So, Mr. Miller, do you recognize that if we had that rooftop solar customers reduce the load on the grid during peak times?
They certainly, rooftop solar reduces with the generation, it reduces and impacts the amount of energy that's purchased by New River. As Mr. Halley's testimony indicated and what's been discussed in the previous days, how it impacts the demand is what's gone through the calculations by the representative from Map Voices and New River is how that's calculated. But certainly a customer that has generation reduces the amount that comes from our wholesale provider.
Yeah, Mr. Miller, do you recognize that we've had unprecedented heat waves this year, and that just last week we broke 3 global temperature records, three days in a row, and so that heat waves are a problem? Do you recognize that, sir?
I'm certainly aware that we've got had some hot weather, sure.
And Mr. Miller, are you aware that the average income in the town of Boone is about $25,000 a year?
I have certainly worked with a number of civic organizations and community organizations that recognize the demographics of Watauga County, and that we have quite a bit of generational poverty in Watauga County. The specific footprint of New River Light and Power is unique in that we have a large number of college students and a large number and renters and folks that do not actually have a long-term residency. And New River typically will see 2/3 of their customers leave every 5 years. It's just a rotation. I can't speak to the demographics, but it's unique to the salary of New River's territory of what their income is. I'm not aware of that.
Mr. Miller, would you agree with me that probably 3/4 of the customers of New River do not have air conditioning?
I am not aware of the statistics of without air conditioning at all. No, I can't speak to that.
Does New River have any plans for a cooling center if Boone should have a heat event such as they had in Portland, Oregon, where it hit 116 degrees last year?
Being part of Appalachian State University, we have a emergency center with our convocation center. Where there's any kind of an emergency, we can certainly stage that. It's one of the reasons why our convocation was built, is a center for people to retreat to. That facility has backup and is also served by New River.
And one last question, Mr. Miller, on fuel. New River Light and Power had to purchase $7 million worth of additional fuel in order to cover costs due to, as many people have said, significant increases in fuel costs in 2022. Are you aware of that?
Absolutely.
$7 million.
I'm aware of the significant increases we shared in previous testimony.
And
We had an increase in, all utilities had seen an increase in generation costs or purchase power costs, certainly.
so, Mr. Miller, then, if I look at your revenue requirement, which I believe is about $42 million a year, that $7 million is a significant percentage of that total revenue requirement, is it not?
$7 million is a significant portion of our budget, yes.
Okay, I have no further questions. Thank you.
So it's now time for our afternoon break. It's 3:22, so let's come back at a little more than 10 minutes, 3:35. We'll go off the record. It's now 3:36. Our goal and intent is still to finish by 5 o'clock. I'm thinking that we can do that. So we'll continue to try to be as succinct as possible with all of our questions. And with that, I believe that it is redirect by New River.
Mr. Miller, you were asked about the average bill and whether that of New River might go higher than other utilities. Do you have a comparison that maybe is different than the number that Mr. Hinton had in his direct testimony that you were cross-examined about?
Yes, I do. Thank you.
And can you tell us the source of your information?
Sure. From the Duke Energy Progress Schedule order that was filed with the public staff, the effective rates, which is the phase-in rates through 3 years. The proposed monthly rate for 1,000 kilowatt hours for a residential customer, year 3 would be $150.41. Likewise, Duke Energy Carolinas for the same 1,000 kilowatt hours would be $134.63. While after all of the discussions with public staff and the settlement and the working with the accountants, New River's calculated cost for 1,000 kilowatt hours would be $131.95, and that's under the current PPCA.
Would that last number you said be for the rates as proposed in the application after year 1?
That is a correct statement.
And the settlement rates would be lower than that?
That is correct.
Thank you. Have you seen a letter on energy that was approved by the Boone Town Council this summer?
On June 28th, the town council presented a letter and it was approved, got confirmation. That letter, in brief, does not mention any request of $2 for a standby charge.
And last question here. I believe Ms. LaPlaca asserted that the average income in Boone was $25,000 or so. If New River were to completely eliminate the standby charge, is it likely that many people who have an income of $25,000 are going to be purchasing rooftop solar?
I understand that the cost of the rooftop solar for 10 kW was $30,000. So I really have a hard time understanding why a customer would spend a year of their income towards rooftop solar.
That's all. Thank you.
Okay, so Mr. Miller, just a couple of very brief questions about New River's plans for the DSM EE programs and also the winterization program. And you testified in your rebuttal testimony that that New River would be proposing DSM EE programs and winterization programs when grant funding became available. Can you just briefly describe the status of either applying for the grant funding or progress in receiving it, so we'll know where New River is in that process?
Absolutely. New River continues to seek funding. We historically have worked with Appalachian State. We've been successful in receiving a number of grants through the American Public Power Association. We worked collaboratively with Appalachian's analytics department, developed and studied customer behavior. That is in the past. We have gained, but we continue to pursue grant funding, work with the Energy Center with DOE grants. We're constantly looking for ways of funding, specifically to the IRA grants. We have hired a consultant to assist us identify and, quite frankly, go through the difficulty of the alphabet soup of trying to pursue these grants and funding. But we have are paying for someone to assist us with that. We use Strategics, which is a great supporter of many public power or public utilities. Also, we have hired a grant writer that we have employed, and we've actually been successful working with the town of Boone, filing for a joint grant for electric vehicle funding. So we are making efforts to better our community and work to seek funding and bring that in. Specifically, moving forward, we are a member of a joint action agency, Electric Cities of North Carolina, which represents over 70 public power utilities in the state of North Carolina. They too are looking for larger grants that we could work collectively and collaboratively. So I'm working closely with Electric Cities of North Carolina of how we can bring those fundings in. As always, to implement any kind of energy efficiency, weatherization, demand side management, it takes an effort and takes funding just to administer that. Met with the Energy Center to see at Appalachian to see if they could facilitate that. The current effort that we have, similar to our Roundup program, where we receive funds from customers to help others that are in need with their bill pay. New River identifies and recognizes that to administer that program, we don't have the social and the counseling skills to do that. So we've outsourced that and actually worked with another nonprofit to distribute those costs. We believe that one of the options we have is to also find a third party to help us administer these grants once they come in so that they're sent to the right folks in the right method. We're looking for that funding to do that. Again, I do not want to bring additional costs to New River just when it's a loss for us. So given the demographics, the majority of our customers are renters, they don't own their homes, and they do not stay with New River. It's very difficult. We're a unique utility in that regard, as mentioned by Mr. McLaughlin. So that's a concern. We have no industrial customers. So we are a unique utility, and we are looking for how we can best serve those customers and that unique demographic that we have in the high country.
Thank you for that information. I just have one more question. This relates to the new proposed PPR tariff. And the previous SPP buy all, sell all rates, I think the testimony was there was only about 15 customers that had subscribed to those tariffs. Are you anticipating to see more customers with the PPR tariffs, or do you have any idea whether you'll get better subscription to this new buy all, sell all tariff?
I would like to think that we would get better subscription to the buy all, sell all. I will share with you one of the concerns that I think we all have is that we send the right price signal to our customers. One of the concerns that we have at New River, we're not looking to make anything off of our solar programs. We want to make sure that if we offer the right price signal, a customer chooses to invest several thousands of dollars on the solar system, that 5 years from now, we find out that we overestimated the benefit of that solar. And now, because we want to avoid cross subsidy, we're having to lower those rates moving forward. That causes a very difficult discussion with our customers that made those kind of investments. So I would like to think that our demand side or our new net billing rate will offer the correct price signal, and we are eager to make sure that we continue to fine tune that to make sure the signal continues. As far as the buy all, sell all, New River has that existing rate. It was an incremental cost to bring that in. From the utility standpoint, we're indifferent. We're trying to make this as an offer to our customer. Buy all, sell all, many customers, we want to give the option to them. There may be a customer that does not want to put or cannot put solar on their roof. We give them the option to install a separate system. It's buy all, sell all. They can actually have a separate meter and gain a benefit from still choosing to install their own solar. As far as New River is concerned, the substation meter slows down when solar is installed. Whether it's net billing or buy all, sell all, we're buying less from our wholesale provider. So we're indifferent to that. One is one of the benefits we have of entering our new wholesale agreement is that we have that kind of flexibility with generation.
Okay, thank you. Questions from the commission? Chair Mitchell?
Just one question, and I'll follow up on your last point. So your existing wholesale arrangement does allow you to meet your needs with additional generation?
Absolutely. We have a full service purchase contract with Carolina Power Partners. Part of that contract allows us to pursue other sources of energy, but that's a full service contract. I'll let you ask the question.
Yeah, and so that, I mean, my question really was, do you have the flexibility under the contract to enter into additional arrangements for power supply?
Absolutely.
Okay. And you've heard my questions to the public staff regarding the fuel price volatility and your customers' exposure to that. Does Carolina Power Partners do anything to mitigate fuel price volatility, or is there any provision in the contract that provides some measure of protection for your customers?
There is a provision in the contract. It's somewhat of a multi-party contract. We actually are purchasing our gas free of taxes. It's through a peak, through another vendor. And that gas purchase, we are looking at a long-term hedging strategy. And that adds a little bit of complexity to the effort, but we are making steps to hedge, if you will, future costs of gas.
So I'm sorry to interrupt you. So New River purchases its gas separately from the power supply contract?
Technically it's purchased separately from, because energy is a pass-through to us, yes.
Okay. Were you in the room when I asked my questions regarding backstand service?
I believe you're referring to the December Christmas Eve event.
Well, yes, I asked Mr. McLaughlin about Kings Mountain performance during Winter Storm Elliott, and he said the information that he had was confidential, so I did not pursue it with him.
Okay.
But my question is, does New River have to independently seek backstanding service, or does the contract with Kings Mountain indicate that Kings Mountain will provide backstanding?
It's a full service contract. They have that responsibility of providing the commodity to New River, regardless of the demand, regardless of the amount of energy requested. They have to provide that, and it's their penalty, their cost if they're not able to provide it.
Okay, so during Winter Storm Elliott, was there an interruption in service to New River?
There was an interruption to service to New River, but it wasn't generated by Carolina Power Partners. It was generated by Blue Ridge Energy, who had the request for curtailment by Duke Energy. We saw that as an emergency, and we responded per the request of our transmission provider that we were about to lose the grid, and so we took actions. But it was not due to generation. It was due to the our contract with Blue Ridge and Duke. They made that request. It was not Carolina Power Partners.
Okay. All right, nothing further. Thank you.
Commissioner Gladfelter.
Mr. Miller, I'll be quick. You're the first witness from the company. I've heard a number thrown around, but I have to have you confirm it so that it's official in the record. Is it accurate that you have, aside from ASU, let's leave them aside, only 15 customers who are interconnected to your grid and are operating solar photovoltaic generating facilities in parallel with your system? Is that accurate a number? 15.
We have 15 under the buy all sell all rate. We have
Thank you.
3 customers we believe that have left that are still solar. Yes.
Everybody else has said it, but I need to hear it officially from the company that that's the right number.
That's the last number I had.
Are any of those commercial customers? Or are they all residential customers?
To my knowledge, we may have one commercial customer, but I believe I'm reporting all residential to you, sir.
Okay. Are any of those customers the owners of residential units with multifamily units in effect?
No multifamily
No,
units.
all single family?
That is correct.
All 15?
Yes, sir.
Great. Second question. I'll be quick about it. In your rebuttal testimony, you've offered up and sponsored revised Miller Rebuttal Exhibit Number 1. What is the revision that exhibit make to prior versions of the same exhibit? If you want to reference it, it's Exhibit 1. You talk about it on page 6 of your rebuttal testimony. I just need to tell you to tell me what was the revision that was made. I asked Mr. Barnes about this and he wasn't entirely sure. So you're the sponsor of the exhibit.
And I apologize, sir. I'm coming papers of staff.
Let me read it to you to save time. You say on page 6 of your rebuttal testimony, NRLP has adjusted the amount of renewable energy utilized in its development of Schedule NBR and Schedule PPR to recognize the portions of the hourly load data missing from its initial analysis. This revision is shown in Miller Rebuttal Exhibit Number 1. How was Exhibit 1 revised? What did you do?
I think it was just an update of the original data, and what we did was we revisited the solar load. What we had with our AMI system is that the hourly data was collected, and there were hours that were missed.
Right.
That missed data, when hour 1 read 6, hour 10 read 30. We averaged those. And that was the only update that we had on this. We averaged out those hours.
So the revision made in Exhibit 1 was to average the available data and apply that average to the missing data. Is that accurate? Is that what you just told me?
I'm going to have to ask when Mr. Howley comes up to make sure he verifies that. But
That's fine.
that's the
I'm
best
not
time-
asking about how that calculation entered into his calculations. I just want to know what the revision to the actual data was.
I can't answer that.
Okay,
sir.
thank you. Then the last question for you is, what steps is the applicant taking going forward from this point to ensure that future data collection is complete and accurate in terms of hourly solar production data? What
Yes,
steps
sir.
are you taking?
Yes, sir. February of 2022, we upgraded our AMI system, and the collection is much more efficient, much more accurate, to where we do not have those major gaps. We also, upon the adoption of this, we are obviously going to be monitoring the solar hourly reads to make sure if we see a trend where we're missing data, it would be collected and corrected promptly. It is not something that we are proud of, that we have these gaps, and it has been corrected since the revision of our AMI system to where we are now collecting, the meter is now storing that hourly data and dumped and recorded correctly or more accurately. So not only have we done something since this data was collected, we have also taken proactive steps to ensure it will remain accurate.
So your data set is complete from what date forward?
We had the upgrade on February 2022, sir.
Okay. Thank you. That's all I have.
Commissioner McKissick.
Thank you. Just one or two questions. And I certainly appreciate your testimony about what you plan to do moving forward when it comes to DSM and EE. And the thing I'm trying to understand, I guess the stipulation of last rate case kind of indicated you're going to go out there and evaluate these things. And what have you found based upon what you've evaluated in the past? I mean, what options that you actually explore? What did you actually do? Given the fact that you only have like somewhere between 800 and 9,000 customers, I might have understated that a little bit earlier. Mr. Hint was on the stand, but I mean, what actually occurred that you can share with us that will provide some insights in terms of a thorough evaluation, analysis, findings that were made? Because I don't see any record of that.
And I apologize for not having the record, Commissioner.
Sure.
What we have done is, and I mentioned a number of these grants, as a very small utility with 8,500 customers and 31 employees, we have taken proactive steps and worked closely with a number of efforts to fine tune and focus on the efficiency of our utility. We cooperated and joined NC State with using our AMI data and properly sizing our transformers. It addresses two things. It addresses losses, and it also addresses, quite frankly, the supply chain issues that we have with material and the high cost that we're seeing with our material. We avoided a significant amount of dollars of just our distribution transformers. That's one example. The second example is just system losses as a whole. We're using our AM data with the cooperation with a number of students and professors at NC State with that APPA grant. That's just one example that I took from that. We have spent a large amount of our effort working with our CPP contract and trying to promote our green power program and making New River aware in the community of how we are collaborative and part of our community. Again, our statistics we're very proud of the statistics of reliability and response to our customers. With 8,500 customers, we continue to see positive numbers from our residential and commercial customers, the level of service. What we're doing as far as DSM or energy efficiency, we're really targeting on trying to gain funding and trying to find these programs that actually provide benefit and not an extra cost to our customers. I see my peers in public power working with the folks at electric cities that the rebate programs, the weatherization programs are something that we struggle to see if they benefit the general public. New River, though, continues to offer free energy audits to our residential customers. Customers that request, we will come in and actually do a survey of their home and provide an audit for them to give them opportunities to improve their efficiency of their home. And that's free of charge. We bear that cost. We see that beneficial.
Well, I certainly hope moving forward, the consultant that you plan to hire that will help you do an analysis, evaluations, be able to provide some very thoughtful insights and come up with something that's constructive, because I think we would want to see DSM and EE vigorously pursued to the extent it's feasible, viable to do so. And I'm just curious, I mean, when this utility was started, I mean, it was to provide service to the university, and then it expanded over time. And
that's correct. 1915, we began with 3 light bulbs outside of the college. Yes.
And I guess there weren't other service providers that were, could provide service at the time to contiguous areas.
It was before the RAI, before the New Deal, and before the rural
Sure.
electrification. So we were an island for many years, providing electric service.
But you're no longer an island. I mean, has there ever been given some thought to the idea of being acquired by some other larger utility that might have greater capacity? Has that never been really evaluated or conceived of as an option if you were looking out 5, 7, 10 years?
Sure. Well, sir, I believe we have clear capacity to continue to provide service. Again, our rates are among the lowest in the state, continue to be that way. We have a defined territory. It was the Territorial Law Assignment Act restricts us to a certain area, and inside that area, we excel. As we are able to continue to provide the high level of service to our customers at a very low cost, I believe that we're in the right place at New River to continue that service.
So I take that to mean that the possibility of being acquired by another utility has never really fully been evaluated, or there would be little interest in doing so.
From my position, there's little interest in pursuing that. So, yes, sir.
I can see how that might be. Okay. Thank you. I have no further questions.
Commissioner Duffley.
You mentioned the Territorial Assignment Act. Was that 1965? Do you
The
remember?
1965 Territorial Assignment Act, but actually we have a separate agreement with Blue Ridge Energy that defines our territory.
Okay, and is that filed with the commission?
I believe it is.
Okay, and could you provide that as a late filed exhibit, please?
Certainly.
Okay, thank you.
Okay, questions on commission questions, beginning with Appalachian Voices.
None from Map Voices, and I've been authorized to represent on behalf of Ms. LaPlaca that she waives any questions on commissioner questions.
Okay, thank you. From the public staff?
No questions from public staff.
Okay. From New River?
You discussed a moment ago bill comparisons and the relatively lower rates in New River Light and Power. If, in response to Mr. McKissick's question, hypothetically Appalachian State were to look into selling this, what's the likely outcome of that for residential bills?
Significant increase in cost to every customer class. Residential bills will go up. We continue, even with the proposed rate adjustments, we are substantially lower than the surrounding utilities. So you would see an increase in cost to every customer of New River.
That's all. Thank you.
So now I hear motions from New River and from Appalachian Voices.
We would move that Mr. Miller's 2 direct exhibits and 2 rebuttal exhibits be admitted into evidence.
Okay. Seeing no objection, your motion is allowed.
Voices would move that Appalachian Voices Cross-Examination Exhibit Miller Direct Exhibits 1 through 4 be moved into the record.
Okay. And with no objection, your motion is allowed.
And
I'm sorry?
sorry, Commissioner, I believe I neglected to move Cross-Exhibit 1 for Mr. McLaughlin into the record.
Okay, would you like to go ahead and make that motion now then?
Yes.
Okay. Seeing no objection, that motion is allowed as well. Mr. Miller, thank you for your testimony, and you may be excused.
New River Light and Power next calls Mr. Halley.
Good afternoon, Mr. Halley. Place your left hand on the Bible and raise your right hand. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Would you please state your name, business position, and employer and address for the record, please?
Yeah, my name is Randall Halley. I am a managing principal at Summit Utility Advisors. Business address is 7614 Lake Drive, Orlando, Florida. And that was it, right? Okay.
That's good. And did you cause to be filed in this proceeding 50 pages of direct testimony with exhibits, I believe, REH 1 through 24?
Yes.
And of those exhibits, are the exhibits REH 12 and REH 20 confidential?
Yes.
Okay, and did you also cause to be filed amended exhibits REH 3 version 2, REH 13 version 2 on April 10th, 2023?
Yes.
And did you cause to be filed 26 pages of rebuttal testimony with Halley rebuttal exhibits 1, 2, and 3, and also REH 3, REH 8, REH 13, REH 14, REH 16, REH 19A G, REH 19A GL, REH 19A R, and REH 19B on June 23rd, 2023?
Yes.
And have you caused to be filed 3 pages of, 2 pages of summary of your direct testimony on July 7th?
Yes.
And 3 pages of summary of your rebuttal and settlement testimony on July 7th?
Yes.
And did you also cause to be filed finally 6 pages of settlement testimony with Halley settlement exhibit 1, REH 14, REH 16, REH 19AR, REH 19AG, REH 19AGL, REH 19B on July 6, 2023?
Yes.
And do you have any corrections to any of that testimony?
I do on the rebuttal. On page 5 of my rebuttal testimony, on line 8, starting at second, that there is a sentence that says the rate design above actually should be referencing Halley rebuttal exhibit 1. And then on line 15, where it says the numbers in the above table should reference Halley rebuttal exhibit 1. There was typos in those 2 lines.
And with that correction, is your testimony as filed otherwise the same as you would present today?
Yes.
We would ask that those testimonies be incorporated into the record as if orally read from the stand, and that his exhibits be marked for identification as pre-filed.
And so Mr. Halley's direct testimony filed on December 22nd of 2022, consisting of 50 pages. His rebuttal testimony filed on June 23rd of 2023, consisting of 26 pages. Settlement testimony filed on July 6th of 2023, consisting of 6 pages. The 2 summaries that were filed will be copied into the record as if given orally from the stand. The exhibits and the amended exhibits, 24 exhibits and amended exhibits filed with direct testimony. The exhibits filed with the rebuttal testimony, and the updated exhibits filed with the settlement testimony will be marked for identification purposes as pre-filed.
Thank you. Mr. Halley is available for cross-examination.
Appalachian Voices.
Thank you. Good afternoon. Nick Jimenez for Appalachian Voices. Mr. Halley, you testified in your direct testimony, this is page 47, line 11 to 15, but I think you could do it from memory. NRLP is proposing schedules NBR and IR, net billing and interruptible rate schedules. Yes. Okay. Were you present for Mr. McLawhorn's testimony earlier today?
Yes.
Is it correct to say that under the CPP contract, NRLP incurs greater costs during periods of high demand than during other hours?
Yes.
And those costs are based directly on the per unit dollar per kilowatt hour, rather dollar per kilowatt demand costs under the CPP contract.
Yes.
So compensating customers on schedule IR, interruptible rate customers, at an averaged flat volumetric rate for demand reduced over the course of a month would not reflect the actual cost avoided by reducing demand during hours that coincide with a monthly peak, right?
Are you saying on the IR rate?
On IR, using that as a, yes, on IR.
Yeah, if the customers on the IR rider do not curtail during that one peak hour, they do not get a rate reduction.
If they did curtail and you compensated them, NRLP compensated them at a flat, averaged flat volumetric rate, that would not accurately reflect the costs that those customers avoid, right?
Sorry, repeat that?
I'm trying to skip through here, so I'm
Understood.
lacking some of the background that I intended to cover. On schedule IR, $14.26 per kilowatt for reduction in demand during coincident peak, right?
Yes.
If instead they were compensated at an averaged flat volumetric rate, say the coincident peak is 2 hours, and they were compensated at an average flat volumetric rate, the retail rate during that period, that wouldn't reflect the costs that they avoid, that they allow New River to avoid, would it?
I'm sorry, I'm still not following the question.
I need to back up.
Can I rephrase what I think you said?
Sure.
Are you asking me that if a customer on the IR rate reduces their peak in that 1 hour, that they would get that reduction in the KW charge? And then are you saying, does that affect their whole cost of energy for the month?
I'm trying to relate the cost of energy close. I'm trying to relate the benefit that the customer receives on proposed schedule IR from reducing during coincident peak to an average flat volumetric rate for the cost of energy during that coincident peak period, not over the whole month.
Well, if they're on schedule IR, the customer is already going to be on schedule GL, which is the large general service demand rate. So they're already paying an energy charge that's based on the cost of service for that demand rate. The only reduction they get from the schedule IR is if they are successful in reducing their peak in that 1 hour that matches the CPP hour. That's the only time they would get a credit. If they miss that peak, they get no credit.
And that credit's based on the cost that their reducing demand allows NRLP to avoid under its contract with CPP.
That is correct, yes.
Okay. Let's move on. Okay, were you present for witness Miller's testimony on cross-examination earlier today?
Yes.
Do you have anything to add or correct or disagree with respect to ASU's prior and current net metering or net billing practices?
Current net billing practices. Can be, I mean, is there a specific point you're wanting to clarify or?
Well, we could go back to the exhibits, but I examined Mr. Miller on a number of exhibits that reflected an exchange that you and he had concerning potential compensation for an ASU solar facility that could be developed. I just wanted to get your take on his testimony, whether you agreed, whether you had anything to add.
I mean, I don't remember it word for word, but I remember it being fairly accurate to what transpired. Yes.
Thank you. Now I want to see if I understand how you accounted for the value of customer-sited solar provides to the system, or as you put it, the costs that are offset by generation at the customer's premises. You said customer-sited PV did offset a portion of NRLP's costs from CPP demand charges, CPP energy charges, DEC transmission charges, and BREMCO distribution charges. This is page 48, lines 9 to 11. Is that right?
In my direct testimony?
This is direct. That's right.
And I'm sorry, what page was that again?
48.
Four- 40?
48.
48, I'm sorry.
Yes.
Okay, I see that.
And you found the PV facilities were generating approximately 29% of their maximum output during the times of BREMCO and DEC coincident peak hours, and approximately 26% during CPP's coincident peak hours. That's also on page 48, lines 11 to 14, correct?
Correct.
The amount that the customer-cited PV reduces NRLP's demand-related costs should be passed on to the customer owning the generation. Wouldn't you agree?
I'm sorry, say that again.
The amount that customer-cited PV reduces NRLP's demand-related costs should be passed on to the customer owning the generation, right?
In relation to how the residential class rate was designed in that proportion. Because the way we set up the NBR is we took a look at our cost of service, developed the rates. The rates recover the actual cost of service that NRLP receives to recover those rates. We looked at what was the contribution of those solar facilities. Actually, how does that reduce the billing determinants that the residential customers would be paying to New River? Basically, how much energy did it reduce in receiving that New River would receive from the customers buying the power? We looked at that lost revenue piece as the avoided cost that New River needs to recover from its fixed costs. So that's how we utilized the demand component.
I think I'll come to that later. Well, coming back to the percentages that we just discussed, the contribution to peak, you discounted the value provided by solar according to how much you found that it contributed to avoiding coincident peak, right?
I wouldn't say I discounted the solar. I accounted for how much it actually reduced the expense that was built into the residential retail rate.
Okay. You testified that this is page 48, lines 2 to 4. Since NRLP's distribution system costs are fixed in nature, these PV generation facilities do not reduce any of NRLP's distribution costs, correct?
Correct.
So to be perfectly clear, it's NRLP's contention that there is absolutely no portion of its distribution infrastructure investments that would ever vary with sales?
That is correct, based on the rate design we have right now.
And no portion of New River's distribution costs would ever vary with sales or usage?
Correct.
practically speaking, NRLP's distribution system will change over time, will it not?
I would assume so. They are doing investments in the system itself.
It could expand.
If they add customers, potentially, yes.
So there must be some future costs associated with NRLP's distribution system.
Yeah, but when we're designing rates, we're not looking at future costs. We're looking at the actual costs that were incurred in the test year, plus adjustments for known and measurable changes. So that's how the retail rates were designed. So solar is only going to reduce the amount of revenues New River recovers for those fixed costs. So that is where we came up with the charge that we have per kW for the solar installed to make sure those fixed costs are recovered based as we designed to recover those fixed costs from New River's customers.
And your solar value used an averaged flat volumetric rate as the rate at which system value accrues, right?
The solar value in my exhibit 19A, is that what you're talking about?
Yeah, or 19AR, yeah.
We took, again, it's the average cost of the rate that we have to collect the in those rates. So that's the actual rate that we're using as a avoided cost, if you will, for not the avoided cost, I take that back. The fixed costs are the average cost of the residential rate that New River would not have received if all that solar was installed behind the meters. That's the rate that we're using to make sure New River is made whole on the fixed cost.
Okay. I think you're getting to this. You testified that the value of solar can only be worth the amount of actual costs avoided by NRLP at the time a customer cited PV generation is operating. This is rebuttal, page 16, lines 13 to 14. Is that right?
(13 through 14).
Yes.
That is correct.
So I think we agree with that, but from that, you conclude that the value of solar cannot exceed the retail rate. Is that right?
That is correct.
And in your testimony, this is rebuttal testimony, you offer a sort of series of premises supporting that conclusion. Correct? This is page 16. There are numbered premises here, lines 15 through 20, and then a conclusion on page 17, lines 1 through 3. You recognize all that?
Yes.
And the conclusion is all of NRLP's distribution costs are fixed and would not be avoided if a customer installed and used PV generation. Therefore, it is impossible for the value of solar in a net billing arrangement to be greater than the retail rates. Correct?
Correct.
I want to see if I can understand how your premises here lead you to that conclusion. So going back to Schedule IR as an analogy, okay. You recall how we agreed that NRLP incurs greater costs during periods of high demand than at other hours.
They incur greater costs at their CP peak. So yes, that would be the higher demand.
Yeah, okay. And a customer on Schedule IR would be paid $14.26 per kilowatt of load reduced at the time of coincident peak.
Yes, if they were able to reduce during that coincident peak, yes.
If they do it. And that's based on NRLP's costs under its contract with CPP.
Correct.
So isn't it true that anything that reduces demand equivalently would be worth $14.26 per kilowatt during coincident peak?
Well, in essence, we did correct that in the exhibit 19. Again, the way we did exhibit 19, which is where we set up the net billing rider, the cost of service allocates all fixed costs to each customer class. And we're going to talk specifically to the Carolina Power Partners CP demand, since that's what the question I've been asked here. We know exactly how much each of the residential customers contributed to that peak. That allocated demand was at that demand cost was allocated to the residential class. And then rates were designed to collect that demand. So again, the rates we have for the residential class collect all the fixed cost and variable costs that are in the cost of service. Since we only have a basic facilities charge that we're proposing at $14.50, a majority of those costs have to be rolled into the energy rate. So that energy rate that we have ensures that all the rest of those fixed costs are collected. So New River designs a rate based on what the projected energy is for each of those residential customers, and that's how we collect those fixed costs. If we allow solar to be placed behind the meter, that total energy is reduced, therefore reducing the revenues that New River would collect and not collecting all the fixed costs that would be included in those costs. So in effect, we are giving solar the same cost that was being allocated to that residential class.
So if I think I'm trying to pin down the sort of difference of opinion here. If I understand what you just said, the residential retail rate includes fixed costs, and effectively compensating solar at the residential retail rate through net billing avoids those fixed costs. What I don't understand is how that's a limit on the value that solar provides to the system and to NRLP during times of coincident peak. Why would reducing demand in some way be worth $14.26, but solar reducing NRLP's demand from CPP, the same amount, could only be paid the average volumetric rate?
As you pointed out in my testimony, we're saying that on average, the solar only hits that peak roughly 26% of the time. So there's no way they're going to get the full 14.26 cents for the kilowatt. That's why I'm saying that the way we've allocated it in the rate for the residential customer, that rate has to be collected from the residential class. And we do allow a reduction in the BREMCO demand charge. We do allow a reduction in the DEC transmission charge, and we do allow a reduction in the Carolina Power Partner demand charge based on those percentages of the time that the solar is operating when those CP peaks happen. So they are being compensated fairly for how the costs are incurred for the residential class.
Well, so I'm hearing one of I'll just call them discounts because I'm a lawyer and I don't know the right terms necessarily. One discount is the percentage that solar is actually generating during the peak time. And the other one is what you compensate solar for providing that value at that time. So I think we agree, if you were here for Mr. Barnes's testimony, that the sort of percentage reduction, percentage that solar is actually contributing to reducing peak makes sense. But shouldn't you multiply that percentage by the actual cost avoided, whether it's $14.26 times the 26%, say, rather than using the flat volumetric rate?
Again, we are addressing the value of solar to the residential class based on the amount of energy it would reduce. The residential class, again, has a retail rate that is collecting fixed cost in the energy rate. So, you know, you have to, and to ensure that New River is recovering all their costs, the only thing you can look at that's fair is to allow, reduce the demand, or I mean, reduce the energy that New River would collect in that retail rate design, determine how much revenue is not being collected, and then identify what's a fixed charge you need to charge those individual customers who are causing that revenue not to be collected.
Okay, I'm going to try one more because I don't want to take everyone's time. I feel like I'm starting to beat a dead horse here, but you know what? I will not land that last blow on the horse's body corpse. You testified that you used a modified version of the minimum system method, right? This is rebuttal, page 19, line 1.
Yes, I did say that.
And you testified that the minimum system method has been used in the past in North Carolina.
Yes, I did say that.
But as far as you know, the minimum system method with your modifications has never been used before, has it?
By other utilities?
By anyone?
I don't know.
Pass the mic.
Good afternoon, Mr. Halley. Menashe Mager, co-counsel for Appalachian Voices. Have some questions with respect to cost of capital. Start off, New River originally proposed a rate of return of 7.007%.
That's correct.
And this rate of return was based on an ROE, return on equity of 9.6%, cost of debt of 4.2%, and a 52% equity to 48% long-term debt capital structure.
Correct.
In the stipulation, New River and public staff agreed to an overall, rate of return, I should say, of 6.165%.
Yes, correct.
And this rate of return has a lower ROE, lower cost of debt, and has a 50-50 cap structure, hypothetical.
Correct.
Yeah. Obviously recognizing the parties' stipulated positions, would you nonetheless agree that, you know, New River's original proposal, at least from your perspective, was reasonable and is reasonable?
My original proposal, yes, I would say it was reasonable.
Okay. Okay. Shifting gears slightly. In your testimony, I believe this would be kind of dispersed throughout it. You mentioned that there are a couple of factors that sort of drove the rate increase, and those include, I think, 5 specific capital infrastructure investments that you cite or reference. Is that right?
Correct, yes.
Okay. Again, just in the interest of moving things along, obviously, you know, subject to check, would you agree that 4 out of those 5 capital infrastructure investments have, I guess, service lives that would be greater than 30 years? And for reference, this would be the warehouse, the laydown yard, the undergrounding of lines. Basically, it's all the investments except for the SCADA investments.
Gotcha. Yeah, I mean, not a depreciation expert, but that would sound reasonable.
Yeah. And I'm just going off of what you put in your testimony.
Yeah.
Okay. New River obviously is an operating arm or division of Appalachian State, correct?
Correct.
Meaning that it does not have shareholders.
Not that I'm aware of.
Okay. So New River's capital financing needs are satisfied through debt financing and its retained earnings.
That is correct.
Okay. So the 2 utilities that you cite in your testimony as peers and also the reference for your proposed return on equity, are Piedmont and Public Service. Is that right?
That's correct.
And both of them are gas distribution utilities.
Correct.
Would you agree as a general proposition that gas utilities have a different risk profile than electric utilities?
Not significantly. That's why I use them as an example.
Okay. Did you conduct any analysis specifically comparing the risk profiles?
I don't know if I did or not. Do you have reference to it by any chance?
No, I'm asking you, did you conduct any additional specific analysis?
I don't recall if I did or not.
Okay. And Piedmont and Public Service are not state-run utilities.
That is correct.
And their parent companies, Duke Energy and Dominion, those are publicly traded companies.
Correct.
Meaning that their parent companies at least have shareholders who, I guess, expect to be compensated, I should say.
Correct.
Okay. So to be clear, based on sort of what you've testified on the stand and in your pre-filed testimony, the basis for your comparison between New River, Piedmont, and Public Service is that they are distribution-only utilities that are regulated by the commission.
That would be correct.
So still on the same, I guess, topic or subject, obviously, this is a basic point, but Appalachian State, Piedmont, and Public Service, they have credit ratings, right?
Yes.
Okay. And when credit rating agencies rate borrowers or they rate their debt issuances, they're measuring the ability of the borrower to honor their debt obligations.
That is my understanding, yes.
Which depends in part on the borrower's risk profile.
Partly, yes.
Okay. Also depends in part on sort of their financial strength, right?
Partly.
Okay. Again, trying to move things along. So obviously, feel free to answer this to your comfort level. Would it surprise you that Appalachian State has a higher credit rating than either Piedmont or Public Service?
Yeah, I'm not aware of that.
Okay. Okay. So in addition, you cite a value line survey of earned returns on equity, and I might have gotten this count wrong, of 34 electric utilities. Do you recall that? This is from your direct testimony.
What page is that on?
So if we're going by a line number, just give me 1 second. So yeah, this is this is going to be it's going to be page 28, starting on line 13, but it's table 4. It's your direct testimony.
Gotcha. Okay, I see it. And what was the question? I'm sorry.
So I'm just saying that you cited a value line survey of these utilities.
Yes, I
That's
did.
all I'm
Yes,
confirming.
yes.
Okay. So these utilities include both distribution only and vertically integrated utilities.
Correct.
So just to recap, New River, which has no equity shareholders, in calculating its return on equity, it took the average of the allowed returns on equity for 2 gas utilities, took the, I guess, average of these earned returns for these utilities that include both distribution and vertically integrated utilities, and then also sort of looked at earned returns on equity of utilities to determine ultimately its return on equity.
That was my approach, yes.
Okay. All right. Moving on. New River's originally proposed cost of debt was 4.2%.
That sounds right. Hang on a second.
And if you want a,
Where are you seeing this?
so it's actually so it's line 29. Sorry, I need to speak into the mic. It's line 29 on page 2.
That is correct. Yes.
Okay. And so this proposed cost of debt was calculated by averaging the approved long-term costs of debt for Public Service and Piedmont, specifically the cost of debt that were allowed in those 2 cases.
Yes, that is correct. I did that because we were looking at an imputed 50-50 capital structure instead of the 78-20 or whatever the original structure was. So, but yes, that is what we did.
Okay. You would agree, just as a general matter, that when you're calculating cost of debt for rate making purposes, you should be referring to the utility's own embedded cost of debt?
Not necessarily in the rate design perspective, no.
Okay. Okay. You testified, and this is page 30 of your direct testimony. I'm referring here to table 5, that New River's actual cost of debt at the time the application was filed was 2.3%.
That is correct.
Okay. All right. So on page 31 of your direct testimony, beginning on line 12, you propose a 52% equity to 48% long-term debt capital structure.
Yes.
And ultimately, this is a hypothetical capital structure.
Yes, for rate design purposes, yes.
As you admit on page 30 of your direct testimony, this is beginning line 17, the commission has actually approved New River's actual capital structure in past proceedings.
That is correct.
Okay. And in one of those proceedings, the approved capital structure was 6.42% long-term debt to 93.58 equity.
That is correct.
Okay. Just a couple more questions. Should only be maybe 2 or 3 more minutes tops. And we're moving on to your rebuttal testimony. So public staff and app voices obviously have both contested cost of capital.
I'm sorry, say that again.
The public staff and app voices have both contested cost of capital in this proceeding.
Correct.
Again, just to eliminate the need for having exhibits, do you recall providing in response to discovery that the reason why New River did not submit, I guess, a DCF analysis was in part to basically save costs to ratepayers. Do you recall that as a discovery response?
Yes, we did not do that one to save costs, but we also knew that the DCF model, in my opinion, does fluctuate drastically given inputs that you put into the DCF model.
Do you also recall saying that you did not, and this is again in response to a discovery request from App Voices, do you also recall saying that another reason why you did not conduct a DCF analysis is because you have no experience working with DCF analysis?
That is correct.
Mr. Halley, you were a cost of capital witness in the E-34 sub 46 proceeding, is that right?
Was that the last one for New River?
Yeah, it's the one that was filed, I think, 2017.
2017.
Yeah, that sounds right. Were you here, or do you recall some of my, I guess, conversation with witness Hinton with respect to how you calculate a DCF analysis?
I remember the conversation you had with Hinton, yes.
Okay. Commissioner Camright, may I approach? Don't forget the report.
So we'll go ahead and mark this exhibit as Appalachian Voices cross-examination, Halley Exhibit 1.
Yep. And do you recognize this to be your testimony that you filed in that proceeding?
Yes.
Okay. Can I have you turn to page 6 of your testimony, starting on line 152?
Yes.
You see there that you discussed the DCF model or analysis, right?
Yes.
Can you turn to page 7, so the next page, lines 180 through 183?
Yes.
And again, I know I mentioned this more broadly, but do you recall my conversation with Mr. Hinton with respect to in solving for the cost of capital, you take the dividend yield and you add the expected growth rates of dividends to that yield?
I remember you talking about it, whether I followed it or not, no.
Okay. Well, subject to check, actually, let me rephrase that. During that conversation, Mr. Hinton said it would be improper to add an expected growth rate to the denominator and subject to check.
Subject to check.
Okay. And yet, if you look here, it appears that there is an expected growth rate that has been added to the denominator.
In that formula, yes.
Okay. No further questions.
Okay, no questions from the public staff. Redirect from New River.
You were asked some questions about how the interruptible rate was calculated in comparison to the NBR rate. At least with respect to residential customers, does the NBR rate have a demand charge?
The NBR rate?
The NBR rate.
It does not. No, the residential customer does not have a demand charge.
It's strictly a volumetric charge.
That is correct.
And does the interruptible rate for the GL customers have a demand charge?
Yes.
Okay. You were asked some questions about essentially the use of volumetric rate for your calculations here related to the standby charge. And witness Barnes had claimed that you have a math error. Do you agree with that?
No, it was more of a method difference of opinion than a math error. There was no math error in my calculations.
That's all my questions.
I just have a couple of quick questions. Can you provide a little bit more detail about the difference of opinion of, you said that it's not a math error, but you have a difference of opinion, and just provide some succinctly, I would appreciate it, but to explain why you think that your methodology is correct as opposed to Witness Barnes's.
Yes, ma'am, I will. At a high level, again, we did a cost of service to identify the cost to provide service to the residential class. Then we take those costs and design rates to recover those costs. And then that's without solar included. If you take those rates that we designed based on the actual sales that we're projecting, the kilowatt hour sales that we have for those residential class, you will recover all those costs that we have allocated to that class. If you introduce solar behind the meter, that's going to reduce the amount of energy that the residential customers purchase from New River. In essence, not collecting all the costs, so those costs would have to be collected somewhere else in the next rate study, if you will. So that's how I did my calculations. Witness Barnes took the approach of how much is the solar reducing the distribution cost individually outside of the rate design piece. And I differ with him completely. There is no reduction in distribution cost. He's also taking those individual the models that he ran on his solar production model, the PV watt solar production model, to identify what would the demand have been during those peak hours. He specifically applied those rates to those specific hours that he identified that the solar would be running, and giving it a value from that perspective. So the difference is he is approaching it from how is the solar impacting those individual, what would the individual cost be impacted just by the solar itself? I'm taking a look at it from the standpoint, how does the impact of the solar impact the recovery of revenue from the residential customers based on the rate design that we did based on the cost of service. So in a nutshell, is that helpful?
Yes, thank you very much. And then just two other very quick questions. One is we've heard a lot of testimony by the SSC, whether it should be based, the calculation be based on the system design capacity or the nameplate capacity. Do you have a position about public staff seem to agree that system design capacity might be appropriate, and Appalachian Voices strongly believes that. Do you have a position that system design capacity might be a better way for the calculation?
Yeah, absolutely. The intent of the calculations that we did was based on the actual maximum output of the AC to New River system. So if AC nameplate capacity is the wrong terminology to use for that, absolutely. We designed it based on the actual AC output of the system being delivered to New River. So whatever that needs to be called, we are totally open to change the reference to it.
Okay. And then this is last question. This comes from commission staff, and it relates to the basic facilities charge. And in your direct testimony, you talk about the increases in the basic facilities charges for various customer classes. And for the residential customer class, this is pages 44 to 47, but I don't know if you necessarily needed to turn there. You state that the proposed basic facilities charge of $14.50 is well below the residential monthly fixed cost of $36. Can you explain how you arrived at the amount of $14.50?
Absolutely. We, knowing full well you're never going to get the minimum, you're not going to get the $36. We looked at what other utilities were charging, what other utilities were being given approval for in current rate proceedings, and we felt the $14.50 was in line with what was being approved by this commission.
Okay, thank you.
Mr. Halley, I'll try to collapse a few things. I think Mr. Lawhorn kind of said it best, is that the difficulty we're having with some of the disputes about the design of the SSC here is that one group is advocating that you consider the value based upon time differentiated cost analysis. And you, as Mr. McLaughlin says it, you don't have a rate structure that allows you to accommodate that in your cost recovery. So here's the question. There was some discussion that the company is considering bringing forward time differentiated rates. Where does that stand? What's the timetable? And when do you expect New River would bring forward a time differentiated rate structure? That would then enable us to consider your ability to recover through your rates based upon a cost analysis that's also time differentiated. Where do you stand?
I believe that was in Witness Miller's testimony.
Right.
Like, I think it was roughly 2 years is what was listed in the testimony. And the reason for the 2 years is, as he explained, they're still working to make, we just got this, they got the software updated in February. So we need to get a good year or so of data to ensure we agree that that system is collecting the data correctly before we even attempt to try to design a time of use rate.
Okay, so we've got testimony from Mr. Miller that the data collection problems have been resolved as of about, well, a year ago now, February of 22, if I heard him right. Maybe I heard him wrong, but the record will be what it is.
Okay.
It's February of 22 or whatever. But we're going forward, we'll be able to capture accurate solar production data and maybe another 2 years to develop some understanding of where you might come in with time of use rates. So would it not be appropriate then to revisit how the SSC was calculated at the point in time when the company might be ready to come forward with time of use rates?
I think it might be reasonable because at that point, to your point, Commissioner, we'll have the hourly data. We'll be comfortable. Once we come forward, we're comfortable with the data we have. I have not personally looked at the data we've been collecting to tell you I'm comfortable with it yet. But once we're comfortable, that would be, I don't see why that would be a bad opportunity to take a look at this again.
Okay. It may not be as important now as it was earlier in the hearing, but just to close the loop so it's not left hanging out there, what is the revision that was made in Miller Rebuttal Exhibit Number 1? How did it get revised? How was the data corrected?
I did see that exhibit. I'm so sorry.
He's referred the question to you. You're my third try.
I know. I will answer your question.
Okay. Thank you, sir.
And that ties to the testimony on Miller, page 6?
Yes, it does.
Okay, thanks.
Well, it does. And it also ties to Mr. Halley's rebuttal exhibit testimony because he testifies on page 9 that there was no correction made. And I'm just totally lost. I just need to get the record clear.
Exhibit 1. Yeah. Commissioner, Exhibit 1 is the rate schedules that we submitted in Miller Exhibit 1. Is that what you're referring to?
Well, let's look at Miller Rebuttal Exhibit Number 1.
Yes, sir. That's what I'm looking at. And what I have.
And he says that exhibit corrects for the missing hourly solar data. How does it do that?
Yeah, is that? What is that? That's in the rebuttals. Okay, so the numbers that were changed in Miller's Exhibit 1 for the NBR was the actual rate calculations of what the SSC would be for the residential class, for the commercial class, and the commercial demand class. And those were updated based on one, that the updated and the revenue requirement in the, well, this is rebuttal, so this wouldn't include settlement, but this was just updated revenue requirements that we had and getting to the rates that we proposed. But I don't see reference to the hourly load data in this exhibit. And I apologize.
And I'm going to read it for the third time. This is what Mr. Miller testifies on page 6 of his rebuttal. He says, NLRP has adjusted the amount of renewable energy utilized in its development of Schedule NBR and Schedule PPR to recognize the portions of the hourly load data missing from its initial analysis. This is shown in Miller.
No, I'm reading that. I
Yeah,
see that.
so what was the adjustment made to accommodate the missing data? I just want to know how it was changed.
Yeah,
What's the calculation you made? What'd you do?
Well, I can tell you what we did with the hourly data. Would that be helpful?
That's the question.
Okay, I'm having trouble tying Mr. Miller's Exhibit 1 to that, but let me answer.
All I have is the paper in front of me.
Understand, totally understand. In the hourly load data we had for specific CP demands, because we had the CP demand for Bremco, the CP demand for DEC transmission, and the CP demand for Carolina Power Partners. We pulled the actual hourly load data from those 15 customers, and that was the load that we were trying to accommodate for. In each of those in each of those data points, we were missing about, I guess about 17, about 17% is what I recall. And in those specific hours that were missing, we went and looked at each individual customer's load data, and we looked at when was the last data that was saved, when was the first data saved, and then the last data saved. How many hours were in between those two times? Because what's saved is the cumulative amount. And then if it was, as an example, if the cumulative amount was 100 and there was 10 hours in between that, there would 10 kW would have been filled in for that missing hour. Is it perfect? No, but we at least wanted to go back and make sure we had some data points that were reasonable, given the missing data we had, but were reasonable based on those load shapes that we did have.
You took the total that you did have and allocated it back through the missing hours.
That is correct.
Thank you, sir. It's a simple question,
Okay.
and I just finally got the confirmation of what you did. Because again, your rebuttal testimony says you didn't do that correction. You say that on page 9 of your rebuttal testimony, and I just need to get the confusion cleared up. Now, another confusion that you just created for me with your answer to Commissioner Kimmerer. So, in terms of concern about unrecovered fixed costs, that's what you're calculating the SSC to compensate for.
Correct.
Is otherwise unrecovered fixed costs. What you really are concerned about is not the amount of energy that the net metering customer is exporting to the grid. You're concerned about the amount that they're not taking from the grid, correct?
That's correct.
And the inverter has nothing to do with that, does it?
Yeah, that's where I lose. That's not my area of expertise. Again, the intent was what the data that we took is the actual data, the actual load that was put from these actual loads into New River system. So we are taking whatever that needs to be called. I don't know if it's from the inverter amount, or it's the nameplate capacity amount, but we took what was actually delivered to the system at peak times. As an example, if one of the customers, the maximum that they put on in that 1 year period, the maximum was a 9.6 kW. We assume that number is the maximum amount that we would be applying the SSC to.
Thank you, sir. The light bulb just went off. You did that because what you're looking at right now is 2-meter data. You're looking at the data that's coming from the current SPP rate structure, right? Buy all, sell all, where there's 2 meters. You're looking at the second meter.
Yes, sir.
That clears up the confusion completely.
Okay.
Would you, though, agree that in terms of the principle of recovering the cost?
I'm sorry. Couldn't hear you.
Is how much the consumer is not taking from the grid. That's what really matters.
That is correct.
And
That's how
so if we go to a single meter system, the inverter controls the capacity to inject into the grid. But what really matters in terms of how much the customer doesn't take from the grid is the maximum power of the solar panel itself, right?
Correct.
I think we're finally clear. Thank you,
Okay.
sir.
You're welcome.
Okay, questions on commission questions?
No questions.
Appalachian Voices?
No questions from Appalachian Voices.
Okay. New River?
No questions.
Okay. So I'll hear motions from New River and from Appalachian Voices.
We would ask that the exhibits of Mr. Halley be admitted into evidence, his direct and rebuttal and settlement exhibits, and his amended or revised exhibits.
Okay. Seeing no objection, your motion is allowed.
At this time, App Voices would move to enter into evidence Appalachian Voices cross-examination Haley Exhibit 1.
And also seeing that there's no objection, your motion is allowed. Mr. Halley, thank you for your testimony, and you may be excused.
Thank you.
So it's almost 5 o'clock. We have one more witness, witness Jamison, I believe.
Correct.
And from the information that I have, I said we had to finish by 5 o'clock. But I have gotten agreement from the court reporter and from the commission that we really have a drop dead time of 5:30, but the cross-examination estimate is 20 minutes.
Commissioner Cameron, if I may, I'll try and keep my cross-examination questions really, really brief. I think I plan to cut some questions, so I think it'll probably be less than the 15 or 20 minutes that was allotted, so.
Okay, so then we'll proceed, and we will absolutely be stopping at 5:30, but I have every belief that we'll have this hearing concluded by 5:30. So New River can call its next witness.
Before we do that, I do want to make sure the record is complete. The commission issued an order on July 7th, excusing the appearance of witness David Stark and accepting pre-filed rebuttal testimony into the record. I would like to formally move here in the hearing that pre-filed rebuttal testimony of David Stark, consisting of 9 pages in question and answer format and 1 exhibit, be accepted in evidence in the record in the docket and to be copied into the record as if orally given from the witness stand.
And Mr. Cyrus, can you double check to see if it's 1 exhibit or 2 exhibits? Because I want to make sure that we are correct.
I will. Excellent point.
Okay.
It is 2, my correction, it is 9 pages in question and answer format and 2 exhibits. Thank you.
Okay, so your motion is allowed. The rebuttal testimony of Mr. Stark filed on June the 23rd of 2023, consisting of 9 pages and 2 exhibits that are attached, will be admitted into the record.
Thank you very much. New Light Power, I'd like to call to witness stand Vice Chancellor David Jamison, please. Could you please state your name and position?
Let me go ahead and get him sworn in.
I'm
first,
sorry.
okay?
I'm sorry.
And I apologize. I think I just mispronounced your name. Is Jamison, Mr.
Yes,
Jamison?
that's correct.
Okay. If you can put your left hand on the Bible and raise your right hand. And if you will you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, thank you.
Mr. Jamison, would you please state your name, position of employment for the record?
I'm David Jamison. I'm University Controller and also serving as an interim Associate Vice Chancellor for Finance and Operations at Appalachian State University, Boone, North Carolina.
Have you caused to be pre-filed in this docket, rebuttal testimony consisting of 17 pages in question and answer format?
Yes.
Was that testimony prepared by you or under your direction?
Yes.
Okay. Do you have any corrections or additions to your testimony?
No.
Was there 1 exhibit identified in and filed concurrently with that rebuttal testimony?
Yes.
Is that exhibit true and accurate in representing what it purports to represent to the best of your knowledge?
Yes.
At this time, we would ask that the pre-filed rebuttal testimony of David Jamison be moved in evidence in the record in this case and copied into the transcript as if given orally from the stand, and that the 1 exhibit be marked as Jamison Rebuttal Exhibit 1 for identification purposes.
And Mr. Stars, I'm going to have you restate your motion because I just double checked and he has 2 exhibits. So
Okay.
I assume that you would like to have 2 exhibits
I would.
marked for
Thank you very much.
identification purposes.
Yeah, I handed Mr. Howley my rebuttal testimony notebook when he was trying to answer Mr. Clodfelter's questions.
Right. So Mr. Jameson's rebuttal testimony filed on June the 23rd of 2023, consisting of 17 pages, will be copied into the record as if given orally from the stand.
And 2 exhibits.
And his 2 exhibits will be marked for identification purposes as pre-filed.
Mr. Jameson, have you prepared a 3-page summary of your pre-filed rebuttal testimony that's been filed in this docket?
Yes.
Presiding Commissioner, I would ask that that summary also be copied into the record as if provided orally from the stand.
And Mr. Jameson's summary will also be copied into the record.
Thank you very much. The witness is available for cross-examination.
Good afternoon, Menashe Magrier, co-counsel for Appalachian Voices. Good afternoon, Vice Chancellor Jameson. As you noted in your testimony, Appalachian State is subject to a debt management policy, correct?
Correct.
And this informs how Appalachian State manages debt on a long-term portfolio basis, correct?
That's correct.
Okay. I'm going to direct you to, this is page 12. This is line 17 through 21. Just let me know when you're there. Obviously, in your testimony, you sort of talk about the general process that sort of governs the approval of the issuance of debt on behalf of Appalachian State. But to confirm, with respect to debt issuances for utility operations, specifically New River, approval for that debt issuance or issuances would be solely vested, I guess, within the authority of the Board of Trustees.
It provided that the debt that New River incurs does not bind the state. Authority is delegated to the trustee. Oh, sorry. Yes, provided that the debt does not encumber the state or the university, then they have delegated authority to New River Light and Power.
Right. So like a special obligation bond, basically, where you're having the bond be backed up by some sort of stream of revenues. It's not, you know, the state saying we are guaranteeing this.
Right.
Is that accurate? Okay.
We call that pledge revenue.
Gotcha. Thank you. So again, back to debt management policy, there's obviously some requirements and factors that sort of inform how the university system in Appalachian State can manage debt on its books. One of those, I guess, factors or ratios is the debt to obligated resources ratio. Is that right?
That's correct.
And obligated resources, in short, refers to any source of income or receipts as security and source of payment of bonds.
It reverts to an available funds calculation.
Okay, perfect. So again, with respect to the, I guess, debt capacity study, and you mentioned this in your testimony, and I'm talking specifically about the debt to obligated resources ratio, which is about 1.5x. Is that right?
That's the ceiling, if I remember correctly.
For the 5-year study period, that was the subject of the most recent debt capacity study. At no point does the, I guess, debt capacity exceed that ceiling of 1.5x.
That's correct.
Okay. No further questions.
Well, you certainly did expedite cross-examination. Any questions from the commission? Oh, I apologize, Mr. Sires. Redirect. Yes.
Very, very. Mr. Chairman, I think you were asked a question in which it was referenced, and I know others have been referenced, that New River Light and Power has no equity investors. That's been part of questions that have been kind of a mantra. But in fact, New River Light and Power does have an owner, does it not?
That is correct.
And the owner is the owner of its equity, which is assets less its liabilities. Is that correct?
That's correct.
And that owner is the state of North Carolina.
Yes.
Okay. And when we think about risk-adjusted return, you know, owners are entitled to a risk-adjusted return on their equity, are they not?
That would be correct.
No further questions.
Any questions from the commission? Seeing none, there'll be no questions on commission questions. So motions from New River in regard to Mr. Jameson?
The New River would like to ask that the 2 exhibits that were attached to the rebuttal testimony of David Jamison as exhibits 1 and 2 be admitted into the record as evidence.
And at this time, we would also like to move the application of New River Light and Power and the stipulation agreement into evidence.
And that application to include all of the E1 exhibits that were part of that application.
Okay. Seeing no,
E1 schedules.
okay. Seeing no objection, both of your motions are allowed. And Mr. Jamison, thank you for your testimony, and you may be excused.
Thank you.
This comes to, before I conclude the hearing, are there any other matters that we need to address from any of the parties?
Then from the public staff.
Okay.
I'm not sure when the 270-day window is up, but we are prepared certainly to provide proposed orders and post-hearing briefs within 30 days of receipt of the transcript, unless the commission would prefer that we try to do that on a more expedited basis.
So what we're going to be ordering is that proposed orders are due 30 days from notice of the mailing of the transcript. And before we conclude, I wanted to thank the attorneys and all of the witnesses for the really good work and information that was provided, and also for the professionalism in this hearing. And also, we really appreciate the attorneys working with us to be able to finish the hearing today. I think we appreciated that effort to have succinct cross-examination so we could finish today. So with that, I'll go ahead and adjourn the hearing. And again, thank you, everyone.
Thank you.